everybody has preliminary charge packet.
Yes.
So Danielle either emailed or gave you.
Yes, sir.
Okay.
And Judge, we wanted to see if the court, if we're going straight into charge conference, if we could possibly address the defense's lesser included first, just because our office will have to, it's gonna be a long verdict form, and then obviously, argument wise, we wanna know what we're arguing.
Okay.
And then we'll kind of circle back to the charge conference anyway, certain things do or don't need to be included.
All right. Reasonable.
I need a lessons first.
And I printed out, if y'all are okay with me giving it to Brian, just your email of what it was, since you laid it out by account.
Yeah, that's fine.
Copy for the judge and
No
for the
objection.
email.
You authenticated.
Forgot it was you that sent that to me.
Judge, should we do the directed verdict first?
If you want to, we do that first, it's fine. Yeah.
Not gonna take long.
Okay.
I thought we'd go ahead and get that out of the way.
Excellent.
Judge, Dennis is asking, case be dismissed at this point. We're going to adopt the motion that we had initially, that the court heard back several months ago.
The demure, is that what you're referencing?
Special demure.
Okay.
We want to adopt that and add to it, Judge, that in looking at a number of cases, and these are relatively new cases, of course, aware of Melicon versus the state at 319 Georgia 741. We talk about cause and fact and legal cause, which means proximate cause, and then looking at that, foreseeability or likelihood of death happening in a way that it did. Foreseeability on the defendant's conduct. We don't know at this point what conduct is criminal, because it's not against the law to have a weapon or ammunition not locked up. So when they're talking about criminal conduct, then you have to go farther than just the criminal conduct and what that reasonable foreseeability is. We don't believe that the state has shown that. Further, Judge, in looking at Code Section 1611-101.1, I think the state uses the language from that particular code section when they're describing the what they intend to prove on the not large number of counts at the very end of the case, which is the cruelty to children. So we believe that the state does not carry the burden to show sufficient warning, nor have they shown under the two-prong legal cause and cause in fact, the proximate cause, the foreseeability that Colt Gray would plan this out to this extent, and the foreseeability of him being able to take a long rifle into a school goes beyond what I think the state has intended to show in this case. For those reasons, Your Honor, we would ask the court to dismiss at this point. Thank you.
Thank you, sir. Who's responding?
I will respond.
So the court denied the defendant's demurrer motion last year, and essentially the court in doing that, found that the state adequately charged proximate cause within the indictment. So now what we have to show is that we have provided enough evidence for the case to get to a jury for proximate cause, which is essentially their argument that we haven't. In Johnson versus State, which was an involuntary manslaughter charge, and cruelty to children in the second, that was before the new statute for murder in the second degree came about. In that case, a mother left a 3-year-old, a 4-year-old, and a 2-year-old completely unattended for an extended period of time in a room that had a space heater. And in that case, the evidence was sufficient to find that she committed involuntary manslaughter and the commission of reckless conduct. Obviously, owning a space heater is in itself illegal, but the manner in which she owned it was illegal, and that is what the state's contention is. Owning a firearm and owning ammunition is not in itself illegal. Owning it and allowing access to it in the manner that the defendant did rises to the level of reckless conduct, it rises to the level of criminal negligence, and therefore it rises to the level of a criminal act. For proximate cause, for both criminal negligence under Piedmont versus State, 257 Georgia Appellate Court 902, and proximate cause under Butler versus State, 363 Georgia Appellate Court 753. These are questions for the jury to determine. The jury needs to determine whether or not the state has proven criminal negligence and whether or not the state has proven proximate cause, as long as we have provided some evidence that the defendant was criminally negligent and that these deaths were the proximate cause of his criminal negligence. And the state certainly has provided a lot of evidence of warnings that the defendant received in the form of Colt's deteriorating mental health, in the form of the violence that he was showing at home and alluding to in his text messages, as well as the red flags that were clearly present that showed that Colt was obsessed with school shooters. So there's definitely sufficient warnings. Those warnings are what make the manner in which Colt harmed people reasonably foreseeable. I don't believe the standard is that the state has to prove that the death in the exact manner in which Colt committed this crime is reasonably foreseeable, that he took a gun on a bus to the school. But it is reasonably foreseeable that Colt would kill people with his gun and harm people with his gun. And that's certainly when you provide a 14-year-old with mental health issues, with violent tendencies, and a clear interest in school shooters, it is reasonably foreseeable that he will use that gun to shoot people. And the state has provided enough evidence for that to go to a jury.
All right, I do think that proximate cause is almost always a question of fact for the jury to determine. I do think that there is evidence upon which the jury could in fact find proximate cause here, so I will deny the verdict.
And Your Honor, before we move on to charge conference, may I be excused to go continue to prepare for closings?
Yes.
We object.
All right. So coming back to the lessers. All right, so I've lost the email now.
Sorry.
I was gonna say, so the defense wants,
We can start with the ones we don't object to.
okay,
I don't know that they'll simplify much, but on counts 5 and 7. Involuntary manslaughter is indicted as an unlawful act. They are asking for involuntary.
I've lost the email now. was gonna say, so the defense wants,
We can start with the ones we don't object to.
okay,
I don't know that they'll simplify much, but on counts 5 and 7. Involuntary manslaughter is indicted as an unlawful act. They are asking for involuntary manslaughter as a lawful act, and of course, in an unlawful manner. I think under current case law, that is appropriate. So we would not object to that as a lesser included on those 2 counts.
okay.
That's it.
All right, so if I understand the email correctly, then we have, they're requesting 3 lessers for murder of the second degree, involuntary manslaughter, lawful act, involuntary manslaughter, unlawful act, and contributing to the delinquency of a minor.
Yes. We do object to those, starting with involuntary manslaughter as a lawful act. I think essentially to get that as a lesser included, the state would have had to, there has to be some evidence that merits the lesser included, being that either the victims in those counts, count 1 and 3, were over 18, or that there wasn't full excessive pain. I don't know that any evidence has been put forth showing that. I do have a case, it's Castro Moran versus State, and that's 356 Georgia Appeals 248. That's a 2020 case.
Did you say 248 or 348?
248. And essentially that case says, a trial court is justified in refusing to charge on a lesser offense where there's no evidence that the defendant committed a lesser offense. I think there was a question of, for example, the victim's age, that could be appropriate, but I don't know under this situation that it is appropriate.
Is it House or Mr. Barrett?
Mr. Barry. Okay. Mr. Haas.
Miscue.
Judge, so on the involuntary manslaughter, state must prove the defendant caused the death of another person without intending to by committing the offense of reckless conduct, which is charged on other defendants, though in counts 1 and 2, obviously it's charged as a cruelty in the second. We believe, and this will kind of dovetail into the involuntary manslaughter lawful act, because the only difference between the 2 is an allegation of reckless conduct versus committing a lawful act in an unlawful manner, which was likely to cause death or serious bodily injury. We feel it is appropriate due to the fact that he is charged in such a way that he's absent all malice, so without intending to, which is the second element of involuntary manslaughter, causing the death of another person by committing the offense of reckless conduct. So reckless conduct is defined as endangering bodily safety by consciously disregarding substantial and unjustifiable risk that the defendant's act, in this case, leaving access to a firearm and ammunition under circumstances the state intends to prove in terms of consciously disregarding that risk would endanger the safety of another person. Obviously, the conscious disregard must rise to the level of a gross deviation. We think the jury could find that he committed involuntary manslaughter based on the elements of that as applied to counts, what is it, 1 and 3 for the minors involved. Yes, sir. Same thing for the involuntary on the lawful act. If they determine, they being the jury, that the way in which he stored the weapon and ammunition did not rise to the level of reckless conduct, then they could find that he committed a lawful act in how he stored the weapons, because it's not against the law in Georgia to store weapons in any particular way or any requirement that the weapons be locked up. And the jury then determined that the way he stored them, although lawful, still was likely to cause death or serious bodily injury. They could find the involuntary manslaughter lawful act in an unlawful manner, so we would ask the court to include both of those as lessers to counts 1 and 3.
All right. understand Ms. Daniels' argument that you're saying because of the additional elements of the age of the victims, that these lessers don't apply? Is that?
I am not saying that involuntary, so I was only talking specifically about unlawful act. I am not saying that there is not a world where involuntary manslaughter, unlawful act could be a lesser included, but I think the evidence that that lesser included should be given under this Castro-Moran's case is, there's no evidence that is kind of hard to prove a negative. Like I said, we're talking about the elements of age and causing cruel and excessive pain. There's nothing to show that those elements are in question. There's been no evidence presented that those elements are in question. And when the differing elements between the lesser included and the indicted charge, if that's not present, there's no reason, the trial court's not compelled to give that lesser included.
Do you have any case that goes through sort of a factual analysis? I mean, I realize that the general rule, there has to be some evidence to give a charge, but do you have a case that we can use as an analogy, or?
Not for these specific charges. Let me make sure that's the right case here. The Castro-Moran case, essentially, so it's not exactly the same, of course, but that was essentially failure to seek medical care situation, cruelty to children in the second, resulting in murder of the second. And so in that case, so it is, I think it tracks the logic, the case that I provided.
Mr. House, was there a specific case that y'all felt was helpful?
No, Judge, we would just point to the language that the court has already articulated, and that if there's any evidence, the court should give the lesser included offense. And we think there is in this case.
All right. Reserve on that one, look at some cases on the recess here. Are you also requesting, according to the email, contributing to the delinquency of a minor for the murder of the second?
Yes, sir, we are.
Any argument, or did you want to?
Sure, I can go first. So that's obviously a very extensive statute with many different provisions to it, and refers back to a different statute in terms of the definitions. However, what that statute says based on 1612.1 subsection B, subsection 3, is that a person commits the offense of contributing to the delinquency of a minor in this case being Colt Gray, when such person willfully commits an act, or more importantly, as it says in the statute, willfully fails to act, when such an admission would cause a minor, Colt Gray, to be adjudicated to be a dependent child, as such term is defined in Code Section 1511-2. 1511-2, dependent child is defined as a child who has been neglected, as in need of protection by the court. Neglect is defined in 1511-2, subsection 48, subsection A, as the failure to provide proper parental care for control, subsistence, education, or required by law, or other care or control necessary for a child's physical, mental, or emotional health or morals. A child, as it says in the same statute, is considered in need of the protection of the court if that child commits what's known as designated felony, either A or B. The charges against Colt Gray in his indictment qualify as a designated felony under A, and because the way this case is indicted charges Colin Gray, irrespective of intent, with failing to lock up his gun, failing to supervise Colt, failing to provide him with mental health care, that fits the statute. It's clear that he has been charged with what would be the equivalent of designated felonies, and as such, under that statute, would be defined as a dependent child who's been neglected by Colin Gray's failure to do certain things. This statute fits, as the court stated. There is evidence. There's only slight evidence necessary in order to give the charge. And in this case, frankly, Judge, this charge fits better with what the evidence that was presented in this case than the arguments that were made in this case than any other statute. So we would ask the court to charge with contributing to the delinquency of a minor.
Judge, I'll address that, and then I do need to circle back to address involuntary manslaughter, lawful act in relation to the cruelty of the murder second charges. But regarding the contributing to the delinquency of a minor, I do have one case. It's Staib, S-T-A-I-B versus State. That's 309 Georgia Appeals 785. That's a 2011 case, and I believe the statutes that is looking at were slightly different at the time. So it's looking at cruelty in the second and then contributing to the deprivation of a minor, but the logic is still the same. That case says that they do not merge as a matter of law. And I think, like I said, even though the statute language might be slightly different, the policy behind the statutes and the wording of them track along with what our statutes are now. The other thing, Judge, and the main issue that we would take with the contributing to the delinquency of a minor, well, we wouldn't disagree with Mr. Hobbs that it could very easily be argued that the defendant contributed to the delinquency of Colt Gray. Adding this as a lesser included is putting a lesser included with an entirely different victim. The named victims in these counts are Christian and Mason, and as well as all the mentally and physically injured victims in the indictments. To include a lesser included where the state has to prove a different victim, which in contributing to delinquency of minor, that would necessarily, under that statute, have to be Colt Gray. That doesn't logically track with how a lesser included works. I can't think of any scenario where you could put in a lesser included that would require the state to prove an entirely separate victim just because that victim is part of the language of the charging statute in the indicted charge.
Passwords.
Sure, Judge. We would just rest on the argument as previously given, in that if there is any evidence, the court should charge it, and we believe there is sufficient evidence in this case to warrant charging contributing to the delinquency of a minor based on the evidence that's been presented thus far.
And Judge, can I go back to the lawful act, unlawful manner for murder in the second?
Okay.
So our argument here is different than that for felony involuntary manslaughter. In that, like I said earlier, we conceded that under current case law, involuntary manslaughter lawful act would be an appropriate lesser included for counts 5 and 7. Because the wording is different for involuntary manslaughter and murder in the second, it doesn't line up to be a lesser included because the mens rea for those two counts, for those two charges, is the same. In involuntary manslaughter lawful act, the pattern charges, so that's criminal pattern charge 2.10.44, specifically says under the bench notes, you must include in your instruction the definition of criminal negligence, which is the same mens rea for the predicate cruelty to children in the second to get to murder in the second. Inherently, if a jury were to find that the state proved criminal negligence as they would be instructed under the pattern by the court, then they have found that predicate mens rea to find cruelty in the second and thereby logically find murder in the second. It's a different language, a different mens rea than laid out in felony involuntary manslaughter. I don't have the case citation in front of me, but that would be contrasted with State versus MacGyver, which very wordily and lengthily lays out the logic of why lawful act would be a lesser included of unlawful act in lawful manslaughter. But because the mens rea specifically in murder in the second is criminal negligence, and because the mens rea for a lawful act in an unlawful manner is specifically criminal negligence, to instruct the jury that they could find it to be a lawful act when if you reach that predicate mens rea, you've inherently committed cruelty to children in the second, would be cognitively dissonant and not an accurate statement of the law.
Yes, on that.
Sure, Judge. So the way this case has been changed is unique to the jurisprudence in this state in regards to Colin Gray is charged with cruelty to the second in not to anyone he ever came in contact with. We've got a couple of different layers in terms of how he's charged with cruelty to the second, in terms of he's charged with cruelty to the second based on what someone else, intervening act, did to these other folks. So what we think is that the way the statute is with lawful, you could still find criminal negligence, yet not find the proximate cause in cause and fact and legal cause necessary to go that further step to the cruelty in the second. Therefore, we think that the evidence that's presented could be criminal negligence under both situations, murder in the second, and also involuntary based on a lawful act, because there is no law that he lock up his guns. And find in both cases that he was negligent, yet not find the proximate cause necessary for the murder in the second, and then they would be authorized to find involuntary based on a lawful act. So based on there being slight evidence or some evidence that would satisfy that, we would ask the court to charge involuntary based on a lawful act.
Judge, may I just briefly respond to that?
Go ahead.
Our position would be if the jury were to find that Colin Gray committed criminal negligence, and then there's no proximate cause, and then something horrible happens over here, and the jury does not find that there's a proximate causation between the two, that's just not a crime. So that would be the jury's prerogative as the finder of
You're
fact.
saying it still wouldn't be involuntary?
It still wouldn't be involuntary manslaughter, it'd be two things that without proximate cause are not legally related.
All right.
And I'm sure they'll argue that.
All right, let's see, argument, so we have cruelty to children, various counts through the indictment. You're arguing or asking for contributing to delinquency. Any additional argument?
No, sir, it would be the same one I've already articulated.
Any additional? We have, let's see, count 6 to 8, 27 through 29, reckless conduct. It says not asking for a lesser included.
We're not asking for a lesser on that, Judge.
Okay.
And they are still asking for furnishing a firearm.
So, boss.
So you're at, but you are asking for furnishing a firearm to a minor?
Yes, Judge, we're gonna ask for, it's on my phone. Furnishing a pistol, it's actually furnishing a pistol or revolver to a minor. So I will go ahead and admit to the fact that that statute does not perfectly track what we have in this case. And obviously the allegation is not that he used a pistol or a firearm. However, the language in 1611-101.1 does use the same language as the cruelty counts as presented in the indictment. The spirit of that law in that providing a firearm to a minor who then does something illegal with it would fit the facts that we have in this case, therefore being slight evidence that it is enough to get the charge to go to the jury, so we would ask the court to charge that.
And Judge, that just, I think that charge just wouldn't follow the evidence in this case at all. So that statute says for the purposes of this code section, pistol or revolver means a handgun as defined in code section 1611-125.1. Again, the court's not required to give a charge if there's no evidence for that. there's been no evidence in this case that Colin Gray furnished a handgun to Colt Gray.
They concede that, they're basically saying, we want to transfer it to a long gun, a firearm.
But that's just not what the law says. I can make my own personal policy statements about whether or not I think that should be illegal, but that's just not what the law says. The law does not say that it's illegal to furnish this kind of firearm
So,
to a child generally.
y'all agree it's illegal to give them a handgun, but not illegal to give them a hunting rifle?
I believe the way that statute is written, it says pistol or revolver, meaning a handgun. However, we believe that the intent of that statute is to prevent an adult from furnishing a weapon, a firearm, to a minor. That's what our argument is. There really should be no difference between an AR style rifle versus a handgun or a pistol. We think the intent of the legislature in passing that is to prevent the same exact act. Therefore, we would ask the court to charge it.
And Judge, they wrote in specific parameters for that, and then under 1611-125.1, handgun is additionally defined. It's, I don't know if the law was written to the exact intent to contemplate every scenario, but the law is very, very clear.
All right. I'll have to look at some case law on the lessons there, so let's go through the charge packet.
Okay. Ready, Judge?
Does everyone's packet have 13 pages? I just want to make sure we're all looking at the same thing.
Yes, sir.
Yes,
Um, So, I know Ms. Daniel's familiar with this, but Mr. Hodge, what we'll do is I'll just go page by page. This is a preliminary charge packet. For instance, if there's no issue on page 1, I'll actually put a check on page 1. This will be a court's exhibit so that they can compare what we said we were, what changes we were making based on this preliminary packet.
Yes, sir.
So, page 1, the only thing that wouldn't be straight from the pattern is the state just asked, it has to, summarize the counts instead of listing every count, but I am gonna read the indictment.
Okay. That takes care of that.
So,
So you're not gonna do the thing that we did earlier? I mean, that doesn't matter to me.
yeah, I think, because with Sumter, it does take a long time. Do both sides want me to just do the summary? As I did in
I don't have an opinion, Your Honor.
jury selection? When we say summarize, I mean like in jury selection where it was basically putting multiple victims' names for each count.
Judge, we don't really have a position on that. We'll leave it to the court.
All right.
I think we did. I'll talk.
Well, I'll decide. I don't.
I just need to know how many deaths I bring, Your Honor.
How many what?
How many deaths to bring.
I think the state may have left out a couple of people that they didn't bring in on the indictment, Moon and maybe Adams.
correct. We did not, Tyler Moon and Lynn Downs did not testify.
So I think we would have to, there was no evidence presented on those counts, so I think we would have to strike those counts.
That's not correct, Your Honor. We had a seating chart. We had a chart with Ms. Ryan, where she said these children were present in the room. Had a separate seating chart that showed them present in the room. People testified they were present in the room, and then there was a video that showed the children present in the room.
Which counts are they?
Those, I have the indictment, Judge, in 1 second.
They are both, of course, only charged regarding mental pain. There are.
So it's count 21 is Tyler Moon. And count 9 is Landon Adams.
is linked, so they're both mental pain, is that right, Ms. Daniels?
Yes,
Is a jury permitted to wholly infer mental pain without any evidence?
Your Honor, there was evidence from multiple witnesses about how the room was behaving, everyone's fear in the room, and then there was also the video that showed the manifestations of the children in the room, so they could use that evidence to make that decision.
Judge, of course, we think those counts should be stricken because there was nothing specifically testified to about that. I can't testify about what your mental pain is. So, you know, the fact that they were all scrambling around on the floor and that sort of thing, I don't think that's something that you can transfer from one person to another.
All right, so essentially you're asking for a verdict.
On those counts.
All right, 21 to 9. All right, we'll, does anybody have a case they want me to read on that?
No, Your Honor, just practicality. We routinely have counselors talk about how children behave and act, and in this case, there's a video of how they're behaving and acting. The jury can use to infer that.
All right. I will reserve ruling there and come back to it. All right. Any other issues with page 1?
Nothing to say then.
Mr. Hobbs?
No, Your Honor, and just for the record, that would be, those are all counter charges, indictment, issue, plea not guilty, presumption of innocence.
Yes.
No objections.
All right, page 2. These are also all pattern. Danielle, is this mine modified direct and circumstantial?
Yes, but all the modified is taken out of parentheses.
Understand.
Yeah.
So the direct and circumstantial, this is the pattern. There's a parenthetical, but I think it's just confusing extra language. Do you remember what it is, Ms. Daniel?
the confusing extra language.
That I take out.
That's not off the top of my head,
All
but
right.
I know that the state does not object to it.
I can pull it up.
She'll pull it up. The defense is asking for grave suspicion. I do get that charge.
And Judge, for the record, the state would object to grave suspicion just based on a litany of case law that says it's not error to not give it.
Overruled and given it.
Okay. Well, with the paragraph at the top.
Someone's present circumstance.
Oh, I think.
All right, we'll come back to that. Looking at page 3, here's the standard credibility of witnesses. Do y'all want their intelligence or not?
No, sir.
Ms. Daniel, do you,
We don't have any position on that.
All right. I'll just take it out. So coming back to, page 2, direct and circumstantial. I generally did the short version, which is what this should be. It it's in the, so it says circumstantial evidence is is proof of a set of facts and circumstances that tend to prove or disprove another fact by inference. I put a period there. I think most jurors know what an inference is, rather than saying, that is by consistency with such fact or elimination of other facts. I
don't even know what that means, but
Well, that's why I take it out.
Yes.
So I put a
I'm
period.
fine with you taking that out of it, no objection. Obviously, it's been movement to get rid of stuff like that as they're doing these patterns, so.
I think they've already redone that one, so they didn't.
Yes, I think so too.
That one they left. No disrespect to Judge McBurney.
Right.
All right, so we've got expert witnesses, we're back on page 3.
Just for the record, Judge,
Yes,
so I guess that means we're done with page 2. So
Um,
no objections to, on our part, to any of the 4 charges on page 2.
All right, this is, should be pattern charge on expert witnesses. I'm assuming no issue there.
No, sir.
All right, so then we've got, I think this was a state request, witness attacked. The only one that this could be applicable is the bias.
I would argue the character of truthfulness shown by specificness as the conduct of the witness in question brought out by cross-examination.
But I think it's specifically related to the witness's character for untruthfulness.
Okay.
Yeah, I think it's that, it's the particular, like, truthful, untruthful, whether it's a reputation or some specific instance. I think you'll get what you want probably on the, within the other charges. You don't want the bias,
Yes, sir, we do.
Ms. Daniel?
We wouldn't object to it,
All right.
and then I don't believe any felony convictions have been tendered for impeachment purposes.
All right. So from that one, I'll get the bias. All right, witness impeached, I generally give the, what's after the or. State has picked up on that at this point, and made that request.
No objection.
All right, so for witness impeached, it'll be only the after the or. We have, we'll just go ahead and count prior statements on page, that's page 3, since it starts there, that's from the pattern. No issues there, I presume.
No objection.
All right, so page 3 is good. Is that right?
Yes, sir.
Page 4, we've got single witness, any objection from the defense?
No objection, and just going forward, we'll withdraw our request on defendant's choice not to testify opposite.
All right, now, you want it withdrawn in its entirety, or do you want me to, the defendant in a criminal case may take the stand and testify and be examined and cross-examined as any other witness? You should evaluate such testimony as you put that in any other witness. I generally give that, I think I've always given that when the defendant testifies.
I would object to it, Judge.
You see, you do object?
I would not.
Okay.
Sorry, Judge.
That would be appropriate.
All right, so I'll just give this top part of that where it starts, however, I will not give that charge.
Can we change the title of that? Defense choice to testify?
Sure. So this 132.15 statement of defendant, that's real, that's not an actual charge to give the jury, it's, I'll call it a bench note.
Yes, sir.
So that's not something I would read to the jury.
We can withdraw that, Judge. Make it easy.
So then we have, your packet, does your packet have limiting instructions? Does your packet have 134.00?
It has.
Okay, so we took out 134.00, there's no classic limiting instruction like other act evidence. but I do think I need to give 13450 here, really conditional admissibility. They heard his statement or statements, they do have to make findings of voluntariness to be able to consider that statement.
Yes, sir.
All right, so I would give 13450. Is there anything else on the bottom of y'all's page 4?
Statement of defendant, 13216.
All right, Danielle pointing out a parenthetical in 13450, in the middle, is only admitted and you may only consider it if you find certain required, and then parenthetical, but disputed predicate facts. I guess that depends on if the defendant's disputing the voluntariness, and I know we had a motion on it.
He did.
Do you want the parenthetical read?
Yes, sir.
Daniel, I'm assuming y'all are fine, but if you're not, let me know.
Yes, sir.
So page 4 then, we've got statement of defendant. All right, you good with page 4?
Yes, sir.
Yes, sir. No objection. I should say no objection to 132.16.
So I need to give 13217 defining voluntariness. I don't think I would be given the parenthetical at the bottom of that charge.
We agree with that.
No objection.
And we would, I believe, withdraw 13218. I don't think that applies here based on previous rulings by the court.
What's your position, Mr. Hobbs?
I think we would ask for it, Judge.
So the rub, and if you go back actually to that 13215 on the previous page, that was really a bench note. Down at the bottom of that, if the court determines the defendant is or was not in custody, the court should give voluntariness charges only. So with Jackson, I did find that he was not in custody when he gave the statements.
Yes, sir, you did.
And again, jury has to determine voluntariness, but 13218 does seem to be more appropriate if he was in custody at the time. What's your position there, Mr. Hobbs?
Well, I agree, you did find he was not in detention at the time, so we'll leave it to the court.
All right. So I'm going to take out 13218, just it's not being applicable. I would, of course, get 13219. So that make the constitutional rights, again, would not be applicable based on the ruling from Jackson Ditto.
Yes, sir.
So I'll take that out. Is y'all's page 5 in there?
No, sir. We have burden of proof as to rights, and conditions of precedent considerations.
Right.
So burden of proof would come out
Yes, sir.
Because of the constitutional rights coming out, so.
All right, so page 5 good?
13250 on my page.
I have a slightly different packet.
It's only 3 lines of that one on our page 5, the rest of it's on page 6.
All right, so let's count that as page 6. Page 5 good?
Yes, sir.
Yes.
Yes, sir.
Page 6. So the state provided a version requirement that statement be voluntary, removes the issues with Miranda and those constitutional rights. Mr. Hodge, you have any issue with what's listed as the state's version of 13250?
I would just object to any of it coming in. 132.5 doesn't fit based on you taking out 132.1 and 132.40, which I agree should take those out. I don't think 132.50 then fits with those other two being out. And I would ask that I would object to the state's version as well. I think it's covered in other charges.
Yeah, that's what I'm looking for, just making sure.
It just, if you read them all,
Yeah.
it leaves open the question, because it says, defendant made a statement, before you consider it as evidence, you must find it's voluntary, and it talks about all the things if it's not voluntary. But it never says, if you find it's voluntary, then it's evidence. So I think it's necessary to kind of close that loop.
Yeah,
I would just say that it does say to be voluntary, and it defines what voluntary is. The statement must be the product of free will and not under any compulsion or necessity imposed by others, which I think is for every, covers that exact same, just doesn't highlight it.
What I'm saying, if you go back to page 4, 132.16, that's where it first starts talking about it. And the first statement is, a statement that the defendant allegedly made is not for your consideration. Before you may consider this as evidence for any purpose, you must have determined the defendant's statement was voluntary. And then there's lots of stuff about what voluntariness is and how if it's not voluntary, you can't consider it. But then you never go back and say, but if it is voluntary, then you consider it as evidence. And I think you need that charge to close that loop.
all right. Over objection, I think it's appropriate. It's really just removing the parts of 13250 that are inapplicable because we don't have to deal with the constitutional rights since it was not in custody. So I will give the state's version there. I was a little confused on 13510.
We'll make it easy. We'll make it easy. We're withdrawing 135.10 and 135.11, Judge.
All right, thank you.
Of course.
So preserving your objection to the modification of 13250 is page 6. Otherwise,
We got one more.
definition of crime. What are y'all's thoughts there? So, and just go ahead and address intent too. You know, I've never tried a case where every charge was a criminal negligence charge. So I've never not given 14110 intent, but I think it creates a problem for us with this being criminal negligence. To give 14110.
I would agree with the court in that I don't believe 14010 fits the charges of this particular case. I would object to that.
Daniel, what's your
So you're just saying take out 14010 entirely rather than adding on?
141.
well, I think Mr. Hobbs is saying both would fall, but if I understood him correctly, but,
You did, Judge.
um,
Covered both. I hope they're appropriate for this case.
And I think criminal negligence instructions, things of that nature would basically fulfill the role of those instructions in this very specific case.
all right, so are both sides then in agreement that 140-10 and 141-10 should be removed?
Yes, sir, and I think that would also be 141-11.
Yes, sir.
All right, so all three of those then, consider both sides will be removed. States asked for 141-12.
We don't object.
Everybody was okay with page 6, getting it pointed out, I forgot to do that. Is that right?
Yes, based on, right, what's been taken out.
All right, so what's the defense's position on 141-12?
What was the state's position?
They asked for
We're
it.
good.
I'm just trying to, I don't know if it fits.
I've stopped using that by and large unless there were some allegations of,
That's our issues. I don't think there have been any allegations that,
I think the natural and probable consequences of those acts kind of echoes a little bit our proximate cause.
And that would be our contention, Judge. These are, in this specific case, with these specific charges, this presumption, which is an accurate explanation of the law, is relevant and will help the jury in making their assessments. They're having to measure against what the legal concept of a reasonable person is. And this, I don't think, has any negative reason. There's nothing negative to keeping it in, and I think it provides clarity to the jury.
so we would object. We'd ask it to be taken out.
You could relate that to Colt. Colin.
All right, I'm
It
gonna
would
just,
be confusing.
I'm gonna hold on to that one for a minute. So just consider that a reserve ruling. Did the state ask for 140-15 multiple ways?
Yes, sir.
And that's based on your criminal negligence, second degree, cruel, mental and physical?
Correct.
Those are the only charges you're really referencing?
I believe so.
Mr. Hobbs?
That's our only objection.
All right, so I'll give that one. We have venue, I'll take a look at the state's version and see if you have a problem with that. And that, some of that is probably just based on my rulings in the past. I don't know why I'm telling a jury, in a prosecution, in any case in which it cannot be determined in what county the crime was committed, venue's proper can be proved in any county. That's just not an issue in this case.
I don't have an objection to the state's version, Judge.
All right. That is what I'm giving. All right. the second degree. It's from the pattern, except the state requested irrespective of malice, which I looked at the statute. It's in the statute. It's also in the indictment. Despite the little bench note or whatever there.
No objection.
All right, so I'll give 21035 with the added element of irrespective of malice. Cruelty to children in the second degree, 22822. I added by consciously disregarding the substantial and unjustifiable risk that this act would harm the endanger the bodily safety of another, inasmuch as that is in the indictment.
And just, we don't feel that that's necessary to include there. I think the other statutory instructions are more narrowly tailored to the statute, and I think it'd be appropriate to keep cruelty, just that 1 through 4.
And we ask that you keep it in. It does track the indictment in the same way that 21035 does by adding that other number 2 subsection there for the state added element irrespective of malice. We think it's the same thing for the next charge. We ask that you keep it in.
Yeah, I don't know that it was necessary to be in the indictment originally. Kind of a lengthy footnote in the demurrer order, but it, I think its inclusion in the indictment puts the burden on the state to prove it here. It's not just what I call throwaway language or elements. So over the state's objection, that will be included with the cruelty to children second degree charge. And we have criminal negligence.
And Judge, we provided that state's version. It does have a typo. To be fair, I think it was our typo, not else, but for goodness sake. The last word there says nearby, it should be thereby. And looking at it against the pattern language, I think it would be clearer and just as appropriate to just add or failure to act to the end of the pattern.
Mr. Hobbs. Originally, I thought, yeah, that makes sense when you're talking about negligence. But when you look at the indictment, it specifies an act. It doesn't, it doesn't leave in there or a failure to act. It is the act of providing the gun.
And we think it would be appropriate just to charge the pattern.
I don't want to run into a situation where, appellate court says, well, that's an alternative way of proving it that wasn't in the indictment.
That's fine.
So I'm going to stick to the pattern on that. We have involuntary manslaughter, unlawful act, should be straight from the pattern. Everybody fine there?
Yes, there's no objection to the pattern.
No objection.
So I would move reckless conduct. In your packet here, you have moved, but to write under the involuntary manslaughter and unlawful act. Go ahead and define reckless conduct.
That's how we have it. I think that would be the clear way to do it.
And that should be straight from the pattern. So any issue with the reckless conduct or page 8 in general?
No objection to the pattern.
Page 8 good?
Page 8 is good, subject to what we've already discussed.
All right, so then the defense has requested the involuntary manslaughter, lawful act in an unlawful manner. And specifically as a lesser for counts 5 and 7, which the state consents to, and also counts 1 and 3, which I have not ruled on yet. So with the language of the charge, at least as for lessers in 5 and 7, does the state have an objection?
No objection to the language of the pattern.
All right. And then you have proximate cause. Is that where? No. So coming back, Daniel pointed out there, parentheticals, involuntary manslaughter, lawful act. The defendant acts or fails to act in a conscious disregard. For consistency sake, would we just continue to say when a defendant acts?
I wouldn't, Your Honor, because I think we're stepping away from the indictment here. If you're talking about a lawful act in an unlawful manner, it kind of leaves the unlawful manner up to them, and now the omissions and failure to act come back into play.
What do you say, Mr. Howe? So lawfully, it's lawful that he had access to a gun, but he had it in an unlawful manner, or failing to take the gun away. Flesh that out just a little bit.
Well, I'm just saying, when you say lawful act, which they're saying having the gun and ammunition is lawful, in an unlawful manner, that's left undefined to the jury because it's not in an indictment. So unlawful manner could be omissions and failure acts. It opens that door for those to be possibilities also. The reason we took them out of the other was because it was limited by the actual charging document. But unlawful manner isn't in the charging document.
Well, I think the act is leaving the weapons and the ammunition accessible, which in Georgia is unlawful.
All right, I'll reserve on that. I'm going to take a harder look at it. All right, proximate cause. So, you know, if you read it as is, state must prove that the criminal conduct was the proximate cause of the injury or death. So, and really, it's applicable to, I guess, every count of the indictment. Is that fair?
Yes.
Yes, sir.
So where y'all have submitted your own request, and each side did, so y'all want to either forego the pattern or?
Judge, we provided, but I think it looks like the way you've got it is the first part of our request immediately under that, which tracks very closely. We don't think that the criminal conduct accelerated injury or death in a significant way applies here. And I believe our version lays that out. So I don't know that the state's request specifically drastically modifies the pattern. We just have the additional language, which I'll discuss with you more.
Y'all's position, Mr. Hobbs?
Judge, we submitted a non-pattern request on proximate cause that shows up on our page 10. We'd be asking for that. Starts the overall causation required.
Okay.
That one.
Say another one too, yeah.
Yes, sir, on ours, it's at the bottom of page 10. You'll get a kind of flesh out our thought there.
Yes, and both of y'all are citing Melanchthon.
So Judge, ours, once you get past the language that tracks the pattern, we go on to talking about that previous requirements is fact intensive, demands mixed considerations of logic, common sense, justice, policy, precedent, which are questions of causation for the jury. That language is pulled directly from Rosenbaum versus State, which is 383 Georgia Appeals 417, which is a 2024 case. Rosenbaum in that language cites Melanchthon, which is 319 Georgia 741, which is also a 2024 case. We felt like that language would be particularly instructive to the jury in this specific case. Those two cases that we're pulling from, and again, we pulled the language directly from Rosenbaum. So Rosenbaum is a murder in the second predicated on a cruelty in the second, of course. So I think the policy behind that tracks cleanly with this case here. That was a case where the defendant allowed his significant other to be alone with children. He knew the significant other was abusive towards, resulting in the death of the child. So I think sort of the mens rea there of knowing what can happen is very analogous to here. Citing Melanchthon is also citing kind of a novel legal issue. Again, these are both very new cases, both from 2024. Melanchthon was a felony murder case predicated on a possession with intent to distribute drugs. And so again, in these cases, I think all three of these cases fall in this sort of intangible proximate cause consideration of the jury. So articulating for the jury what it is that they're considering, I think, can be particularly helpful. It's not harmful in that it tracks the exact language used by the appellate courts.
I don't remember Rosenbaum offhand. I think you may have those reversed. Melanchthon was the abusive, leaving the child with someone who's been abusive in the past.
That's correct. Rosenbaum's a Clayton County case with the husband and wife. The wife was in law school and she was trying to, the defense was that she was performing CPR and the child had injuries came from the CPR.
I do have a copy of Rosenbaum. There's been a petition for writ on that case. That's overlapping.
And Judge, I was combining two cases, so that is accurate, and I do believe I stated correctly that Rosenbaum is considering Melanchthon. The same logic tracks in Eubank versus State, which is a 2023 case. That's the possession with intent, felony murder. That's 317 Georgia 560.
Which I think the defense side's in there.
Yeah, so in response to that argument, the language that the state is asking for determining whether the state has proven these requirements in any given case is fact intensive and demands mixed considerations of logic and common sense. Justice, policy, and precedent, which are questions of causation for the jury to decide. That language comes from Justice Pinson's opinion in Melanchthon. That language is what Justice Pinson is telling the readers he's using to analyze the causation issue. Not that the jury should be instructed to use that. To instruct the jury to use justice, policy, and precedent, number one, opens the door to telling the jury that they are allowed to set policy on a case like that, on a case like this. So, for example, if you have a jury who thinks the gun laws in Georgia aren't stringent enough, they can make their own policy to impose criminal liability on someone else. What's more instructive is going to be Justice Pinson's concurrence in the 2025 case, Adams v. State, which is 322 Georgia 155. Justice Pinson in his concurrence states, based on Melanchthon, what the jury charge for proximate cause should be. And in that paragraph, He does not mention justice, policy, precedent, anything like that. Now in Melicon, after he gives that analysis, he then goes forward to analyze those different aspects when considering what happened in Melicon. So for example, he does look at policy by stating that you can be a mandated reporter, which is a very narrow class of individuals, and fail to report something that then leads to a child's death and only be subject to liability for a misdemeanor, as opposed to not being in this protected class of persons who is required to report certain things. And now you could be charged with murder in the second. And the examples he uses are you could be a social worker, a defects worker, someone along those lines, a parent, a babysitter who doesn't report something and based on that be subject to being prosecuted for murder in the second, as opposed to the policy consideration that's been granted on mandated reporters. And so he does analyze it in those terms, but he's not authorizing that it be used as a jury charge. The jury, when determining guilt or not guilt, should look at the evidence, not other considerations of their version of justice, policy, and precedent. That would suggest we would have to argue case law to the jury in our closing about Melanchthon and Rosenbaum and Adams, Eubanks, and just down the litany of these cases.
From the state's request, is that sentence, the one you've just been discussing, is that the only offending sentence in their charge, or?
It's the most offensive. I'll say that.
I think the rest is pretty much the pattern.
I think the rest is pretty much the pattern.
Is there anything in your?
I will say that, and the state's already agreed, the language about accelerating the death is we would agree is not necessary.
Is there anything in your request that you believe needs to be included somewhere? I mean, I don't, well, I'll just say that. Is there anything in your request that you're like, this isn't covered elsewhere, we need to include this?
Well, I think we definitely discuss foreseeability or likelihood of the death in a different way than the state does, or the pattern.
So it's the legal cause requirement specifies requisite foreseeability or likelihood of death happening in the way it did during the defendant's conduct. Is that
That part, yes. And requiring the death in a way that is reasonably foreseeable, but that's kind of covered by probable or natural consequence.
Judge, I don't know that that's necessarily an accurate statement of the law. I think the way the pattern lays it out makes it clear what the jury is considering. I think once you introduce, so we're already dealing with proximate cause, which they're having to wrap their head around, and then we're bringing in cause and fact and legal cause and defining those and breaking them down. I think it's just getting confusing and kind of derivative. I think it's getting away from what it is that the jury is actually having to consider.
I will kind of take a closer look at the pattern and what each of you requested there. So, if we didn't discuss it, it's otherwise fine.
Yes.
Yes.
We have state's request. What are we talking about now? This is a new one, state's request here. Recordings of interviews. Was there more than We fast forwarded during, investigator gets up, leaves the room, or,
We edited it, remember we had to edit it on the fly, because of.
there was something,
made.
yeah.
So we had to edit portions out.
And just this is a issue that the state's come across with juries, I'd say repeatedly and increasingly, and I would say honestly, the defense has as well, that, the more and more we have reported, and the more and more we have the capabilities and, navigating, redacting things from reporting to place to the jury. It's the state's opinion that it's always going to be helpful to, acknowledge it instead of sweeping it under the rug. If we can tell the jury that, hey, everyone's on the same page here, things weren't played, but don't hold it against either side.
And I think in this case, it cuts quick close, Your Honor. The state fast forwarded it on our motion to get through an activity, but the defense objected, and it's partially edited. So they could hold it either one against either. I think it's just better and safer to do.
Just, we don't have a big problem with this.
Yeah, I don't see any harm in giving it, so I'll go ahead and give that request to charge coming in on redacted videos. All right, I realize we don't have a verdict form yet. And generally what I do in the verdict, generally, I will also hold up the verdict form and kind of explain it to them.
And Judge, obviously, this is gonna be, regardless of the court's rulings, kind of a lengthy verdict form. Are you
Yes.
wanting the state to prepare that, or is your office prepared? Who do you want to?
Y'all have more staff than I do.
All right, happy to. Just wanted to make sure we were.
And we usually just have a blank. We, the jury, find the defendant blank, and I'll say, fill in not guilty or guilty in accordance with your verdict there. So that you guys are aware. Unanimous verdict, court has no interest. And usually do cut down sympathy. And y'all tell me, because of race, creed, color, religion, national origin, sexual preference, local or remote residence, economic status, or against, surely we don't need all those.
I wouldn't think so, Your Honor. No, sir.
All right. Tell me what you want left in. Or do you want me to just put a period after, before it starts that?
Period after prejudice, man.
Yeah, I mean, you are not to show favor or sympathy to one party or the other. It is your duty to consider the facts objectively without favor, affection, or sympathy to either party. I can put a period there, if y'all.
I think that'd be fun.
Or you just put in the citing statutes not be influenced by sympathy or prejudice. Period.
You put it there. Shots.
No, I agree with Mr. Barrett. I think it's fine to put it the period after sympathy or prejudice, and then get rid of because of race. Leave all that out.
Okay. Sentencing standard, deliberations standard. Anybody have any issues with any other portion?
No, sir.
No, sir.
All right, I'll have to take a lengthy recess to kind of sit through the lessers and some of the others. Is there anything else we need to address?
I think if we have time before the jury, it might be time efficient to address what goes back with the jury, but I'll talk to defense counsel about that while you're, on recess.
Y'all may be able to agree on some stuff.
We'll talk, see if we can agree on.
Okay.
All right, pay attention. I'm not sure what we can agree on, but that's fine.
Brian and I definitely agree on it.
I'll talk to Cristina.
Okay, we'll take a recess so I can work on that other. I know that's important. I would give the pattern lesser charge, lesser offense charge, 16011.
Yes,
Straight from the pattern. All right. What is heavy lift?
Yeah, that's fine. Easy to get it stuff.
Ryan said, I think we could go along where she did that, because it was very feels, if y'all want to tell us what you don't. I think
Oh, exhibits.
it's a y'all that I can You do that now, so.
Yeah. We can do that. Why?
Yeah, if y'all want to go through it, I think these facts records, I'm pretty sure we would agree to, the vast majority of the other stuff, I think, our position would be this. So if y'all want to kind of
We have
parse
some
through what you do.
objections we're gonna make about text messages and things like that.
Okay.
I know what the case law says.
Right.
It's more of
Pretty
a,
clear, yeah,
we're trying to anticipate.
right.
They change at some point in the law,
Sure.
but we will acknowledge the case law where the chances on that.
We prepared the PowerPoint without heading writing, so all the
Okay.
content of the PowerPoint without any commentary. So it should just be screenshots.
Check it out.
That's fine. That's pretty good.
It's gonna be gone for.
No.
Cool.
I guess as long as the courtroom's open with security, I think we're fine. You know, that's.
Did you get all that?
Now I'll have to go back over the course, but.
Yeah, it's just, how you all keep up all this stuff. Stuff like that, I know we talk about, I'm trying to slow down.
I mean, ours might work good. Numbers and stuff like that.
Patricia's gonna want to cut specific stuff out before it goes into practice.
Oh, no, I use it
Yeah, I'm
for,
so keen.
body cams and stuff like that, just to get a general idea, but it's messed up all over the place.
I mean, there's certain things that we use in our,
I'm
but
sure.
it's just not.
It's a good guide, but it's not supposed to be accurate, but I couldn't use it in court. Yeah, no way.
They started talking about that now, 20 years ago, talking about.
No, it's not close.
I tried utilizing stuff, not easier for me to do it.
Oh, yeah.
Human interaction is so much more.
No, it can't.
When you have a conversation.
It does a terrible job when people talk over each other, which is most interactions in our job.
It happens all the time. See, we're doing it right now. I did that on purpose, actually.
You are correct. No, you cannot sort people out.
Because that's
We'll just
human
get a
nature.
paragraph.
It's human nature to talk, over someone. Yeah, that was intentional. I'm not that way. I like to prove points.
Good job.
everything that I have over there, so.
Okay.
Business records.
School records.
We won't have it prepared until he rolls on what the lesser included are, and then we'll have the type it up. That would not be good for a script. So yeah, I guess after he comes back. The blank one won't be filed, I said it will be filed once there's a vote on it. When I run downstairs, I'll ask Brad if he's okay. Yeah, once it's done, double check. Yeah, I'll do it. Probably.
I really appreciate it.
Yeah, no problem.
Thank you.
And you don't you can email.
Yes.
Let's take this.
So, obviously this stuff.
Yes, all this stuff, I'm pretty sure this is our problem. Yeah.
I need to go through all your stuff.
I mean,
It's almost getting around.
yeah, I know.
Okay, perfect. I need a witness.
Jenny's our muscles.
Right, right. Excellent. If you're here, that's fine. As long as someone's here, right? I feel weird coming over here.
We're just watching.
Yeah,
For notebooks and stuff.
right. Well, that's it. That's probably the heavy lifting for you.
Yeah, I know.
Me too.
Yeah.
I can sit back and watch.
What the hell am I gonna say for going to
Right,
libraries?
right. The rest of my day is easy.
Yeah.
Perfect.
Well, that's what, like, leading into it, like, Brad was getting ready for cross, which was really close, like, I guess I'm doing the charge, but like, it doesn't
I
feel
can
like
see
anyone
how
else
this is
does.
gonna go.
Yeah. You know, that this last place is charge covered.
Yeah, it's fine. Great. Well, that's
I don't
good.
think they'll get it till, we're trying to do the math, like, 3:30, the earliest.
I think closer, yeah, I think closer to 4 by the time, because it's gonna be a long
He's like,
charge.
Just for guidance.
he's like, if the parties wanna know,
Yeah.
really, yeah.
Roughly time slots.
I know, I kind of wish we had popped in 3 on Friday as far as like, hypothetically, if you want to late or.
Right. Or it's open, like, child care plans.
Yeah.
And stuff like that, because
Right.
sometimes people can't.
Right.
We'll see.
Yeah, and Primm usually pretty deferential to,
Yeah.
like, staying away from.
Yeah.
You don't think he'll charge them tomorrow?
No, I don't think we go, because if we start,
If you start on time.
I was gonna say, yeah, I'm not getting we're not behind as of now, so if we started at 12:30, even if they both took an hour and a half. We will,
Then you'll give them a break,
yeah,
probably in between, maybe not, but definitely after.
yeah,
You think he's gonna charge them today?
I think so, I don't know why I wouldn't,
And then go ahead to deliberations today?
We'll leave that to them.
yeah. So I always like impart my own, like, if I was on a jury, like, I I'm just saying, I just wanna get it done today.
It's hard.
So, like, I don't wanna come back tomorrow, knock it out.
I know, it's hard to predict.
Yeah,
There might be a lot of stuff to go through.
right,
And
yeah, anytime you guys are on. They're very kind of, but not very innovative. I mean, help. Yeah. Yeah, they don't like.
We got a little break.
I can't believe we still have all that. That's what I think, I mean. I feel like we get to a wilderness, like 50% of the time, yeah, I bet. And then normal. Yeah.
5 days. Hey, you got some.
No, they're really late. What is this Ball County? Like,
No,
it's not very nice.
you know, we were joking like the Latino case up here for a while. Hour and a half each way. So
That's a-
driving.
Well, driving from where y'all are over to this side sucks. I take
Where you guys from? He's very young,
Do they have to take two
You have
days
to
off,
buy
right?
but he's 83. That's why I pick him up every day at the office.
There are reasons that Brian drives.
Marietta, right off the square. So it's on the way.
I tried to.
It's a little
I
detour.
tried.
No.
But I've had so many cars with my wife, because I have like a car. She doesn't have to speak, he doesn't
How
have to-
she likes that.
She's okay. She's fine. But it's easy. I don't think how to do it.
Sounds like you're close.
He's gonna be like, finish it up.
Brian's precious.
You're old as shit. Go ahead. You can do this. It's like not your first trial. You're like,
Right. The camera is recording audio, or,
Okay,
so
I thought they were not supposed to
They're not
do
supposed to,
that.
when he's not on the bench.
that's why I'm here. Are they over there?
Television.
Oh, my God, it's not, y'all.
Who's recording?
It's of the seal, but you're
It's
still
just
taking
Brian and
audio.
I shooting the shit.
That's right, yeah, that's right. You got her out.
Well, I'll read those.
Sir, 1 minute ago, text from Ashley Butler. Hot flag.
While you're doing that,
He scared me.
he's on his way. I don't know where they're at.
Just I can look the front. I'll get them. Thank you.
Your Honor, he's on his way up, so we can come out.
Yeah, that's fine. Right. Mhm.
All right, we're all present. To be honest, I'm not sure the door is closed on some further argument or clarification. These are the dangerous waters. That's why I wanted to do this on Friday, but we didn't. So let me start with the directed verdict for counts 9 and 21. I do think that's the directed verdict required. I'm going to cite Jones v. State, 304, Georgia 594, 304, Georgia 594. So I'm grading the directed verdict on counts 9 and 21. Those victims did not.
Jude Byer, from your viewing of the video, when the shooter left the classroom, how did the door get shut?
Based on my review of the video, the door was closed by Christian Angulo.
Nothing further.
Carl? Thank you. Good afternoon, Agent.
Afternoon, sir.
You had a pretty big presence there at the school, I'm sure, by the GBI. Did you have a number of people from your unit there in Athens?
Yes, sir.
How many people from Athens came, if you remember?
Everybody that was assigned to our office, both of our supervisors, every field agent that was working that day, even those that may not have been working at the office, came at some point in the day.
And a number of your colleagues from Atlanta also showed up, correct?
Yes, sir.
Okay. Do you know whether there were any agents there that were doing, say, the investigation of what was at the home of Mr. Gray?
There was an investigation ongoing at the Gray home. I'm not personally familiar with it. I never went there and never laid eyes on it, sir.
Okay. That was not something you had anything to do with?
No, sir.
And did anyone share any of that information with you? In other words, any of the items that were found at the home?
And there were small details coming in throughout the day, throughout the next several days. There were some photographs that were shared. Specifically, I can't recall exactly what all was shared at that time. There was a lot going on in those days.
Okay. And you don't recall who the particular agent from GBI would have gone to the home to do an analysis of what was found at the home?
No, sir, I did not know.
And looking at the video, we see at 8:02, Colt Gray texting someone.
Yes, sir.
Did anyone indicate to you who that might be that he was texting at
No, sir.
8:02?
No, sir.
You didn't collect his phone, correct?
Not personally, no, sir. I transported it at some point to the Barrow County Sheriff's Office for extraction, but I did not personally collect it.
All right. We noticed also in the video that the resource officers go to the bathroom and they pull out Colton Gray, another Gray with similar name.
Yes, sir.
Were they in the same bathroom as Colt Gray?
Yes, sir.
So Colt Gray and Colton Gray were both in the same bathroom at the same time.
That is correct.
Do you know why nobody got the right Colton Gray out of the bathroom?
Not personally, no. To the best of my knowledge, based on interviews that I did with Ms. D. Martin, the assistant principal, there was confusion in regards to the name, and there was also confusion in regards to Colt Gray himself, because he had not been at the school for an extended period of time, and he was lesser known than Colton Gray was.
Okay, so nobody gave anybody a description of who this person or what this person may look like?
That I don't know, sir.
And was there anything else done in relation to this case by you other than dealing with these videotapes?
Yes, sir. I conducted a number of interviews, mostly of teachers and administrative staff at the school. I did not interview any of the students or children that attended the school. Several interviews and video review were primarily the bulk of what I contributed to the investigation.
Okay. Did you do, or anyone with your unit talk to any of the students that were in the same classroom that he was?
There were a number of student interviews conducted by GBI agents. I did not participate in those, sir.
Okay. And no one, to your knowledge, indicated that they had seen this gun sticking out of the cardboard piece that it was in?
No, sir. Nobody, based on the staff members and teachers that I interviewed, nobody told me specifically that they saw the gun. There was a mere suspicion that there was an unusual object in the bag, but nobody was able to identify it as a rifle.
All right. Thank you for your work, Agent.
Yes, sir.
No. All right, thank you. State, any additional witnesses?
Your Honor, no additional witnesses, subject to going through with court reporter to make sure all our evidence has been duly committed on the state arrest.
All right. So, ladies and gentlemen, the state has arrested. I need to discuss some scheduling issues with the attorneys. Go to the jury room. We're done for the day. Go to the jury room, wait for instructions regarding scheduling, okay? And again, don't look up anything that you heard during the course of the presentation of the case. Don't talk to anyone about the case. Continue to abide by it. But you can go to the jury room. tomorrow. Essentially, Mr. Gray, I'll talk about that in just a second, and you anticipate any other defense witnesses.
We expect. Judge, we don't expect any other witnesses other than Mr. Gray. I would anticipate his testimony might take some time. And then, of course, we've got the charge conference. We would like to reserve
So I would need to include in, because what's not covered in that is the intervening act, which I could then take from the pattern unless there was, looking at Melancon, see if there was. Melancon has some other language, as when the intervening act was undertaken by someone other than the defendant who could reasonably be expected to take that action in response to criminal conduct. I'd have to pair that with something else. Having to prove whether the intervening act itself was a natural or probable consequence of the defendant's conduct. The language that we have in our packet for Melancon just doesn't address the intervening act. But like I say, I could charge what I'll just call the Melancon language as the first part approximate cause, and then charge the pattern on the intervening act, which I think you'll see that starts with a bracket on page 10, if the evidence raises the issue of the intervening act.
We understand, Your Honor, you're going to start with the state's request proving all the way down to not merely a possible result, taking out the last sentence. And then going to the top of the page, there may be an intervening act between
That sounds right. Yes,
and then taking out or if the defendant's conduct materially accelerated to that.
yes. And I would charge, I guess, the very beginning of 14160 to find the defendant guilty of murder in the second degree, cruelty to children, involuntary manslaughter. Actually, I guess every count, including the reckless conduct here, the state must prove.
So you want to take out the individual charges, say that to find the defendant guilty, the state must prove.
Could say that. I mean, it
So it's
covers
basically every count.
for the record, Mr. House should have said this. So I think that is probably adequate and safe unless somebody disagrees.
Nothing to say, no.
think we're okay with that, Judge.
All right. Thank you. One other thing, if you look at, it's similar, just above approximate cause, the involuntary manslaughter, all black, almost in there. So the pattern stops after, so you got the three numbers, and then you got to prove involuntary manslaughter, state must prove the defendant acted with criminal negligence. And then the bench notes, you have to define criminal negligence, which I would have already done. But this stuff that's below that it's down in a bench note, and it appears, I don't know why it's there. That's the reckless conduct language that pairs with the other form of involuntary manslaughter, and we generally don't ever tell a jury what's a felony and what's a misdemeanor anyway.
I think it's confusing, or could be confusing.
So
I'm sorry, just starting.
where it says the state must prove the defendant acted with criminal negligence,
Mhm.
what I would add is, which has already been defined for you, because I did that a couple charges ago. But then what's below that, I don't know why that's there. It's actually, it pulled it up from a bench note. It's not actually part of the pattern charge or the law for lawful act in an unlawful manner.
So you're just gonna say as already defined?
Yes, sir. I just want to make sure I didn't miss anything. So Danielle she'll print a clean final version for each of you. Page, I think it's 7, 14112, presumption and inferences. I've got concern about that charge because usually that is something that would go with intent. And we've taken the intent charges out because these are all criminal negligence charges, with some form of criminal negligence. So I'm inclined to take that out. It worries me. It really is in the intent section because we're generally talking about intent crimes and here we're talking about negligence. I don't think the state loses its argument because they're going to get the natural and probable stuff, the foreseeability, in proximate cause. So since we've removed the intent from the other ones, I'm going to take it out here. See if I have questions, and I know you don't have your final version, but I'll give it to you. What I will probably do, since I know closings will be lengthy, is just take a break after the closings. Let everybody look at that final packet one last time, just to make sure I don't say something that's error. Any questions?
No, Your Honor.
All right. So as far as I know, the jury's not here yet, and if y'all need any, additional time, let me know. It's okay if they sit there for a little bit.
Judge, during the break, I had an opportunity to go through most everything that the state has. We do have some objections to certain items. I don't know when you want to take that up.
Yeah, normally I would do it now, but I want to make sure we get this done and we can come back and handle that after closings and charges. Okay, so we'll do it, of course, but let's get the dust settled here. Anything else?
No, Your Honor.
Thank you.
And I think with the red box, the issues on the PowerPoint stuff.
Anything else we giving y'all a final charge?
Yes, we all have.
Hour and a half, I think is what was requested, is that right?
I'll try to be less than that, but just in case.
We have a draft of the indictment, I mean, the verdict form. We added something before we showed them. I'll bring it back.
I have more copies.
Oh, wait, no. And also, would it be possible to take a break after Mr. Berry's closing? We've been going a while, it's like a bathroom break, and I want to set up himself for second closing.
Okay.
And then also, are you intending on us doing a redacted indictment, or you just want to tell the jury to not consider those two counts?
What's everybody's thoughts on
Whatever the court wants.
it? Does the state have a preference?
We don't really feel strongly either way, Your Honor.
I'm sorry, Brian's having to interpret for me today because I can't hear out of the left side of my ear. So I have to look back and forth.
So, the verdict form, of course, goes count 20, count 22. I would probably prefer to give them a redacted indictment, and I will, if I can remember, will tell them, we understand that there are two counts that are not in this, just so that they don't send their first note out going, where's count 21? Yeah, quick look, I mean, I think the verdict form's fine. Did the defense have any issues with it?
No, Your Honor.
Okay. You wanted that back in scrolls?
I know, I have a copy. The original.
All right, are y'all ready for them?
Yes, sir.
Bring them in, Brooks.
Yes, sir. Yes, sir.
All right, y'all can see. Everybody happy with their chair? All right, so ladies and gentlemen, we are at the point of the trial where closing arguments are about to be given. Because the state has the burden of proof, they have the right to give an initial closing and then a final close after the defense. The defense just gets the one closing. What we will do, I do expect them to be pretty lengthy. So what we will do is the state will give an initial close and the defense will give a close. We'll take a short restroom break and then come back to the final close, and then I'll charge you on the law. All right. Ms. Brooks?
41 seconds. On September 4th at 10:22 in the morning, Colt Gray opened fire in Apalachee High School for 41 seconds. Those 41 seconds forever altered the lives of the students of Apalachee High School, their parents, and everyone in this community. At 10:22 a.m., Christian acted and became a hero. He attempted to push the shooter out of his classroom, and when he was shot, Christian's last act on this earth was to shut the door to his classroom to protect his friends. In Miss Ryan's room, the teachers and students acted. Ronaldo ensured the door was barricaded, and Landon held Taylor's hand when she needed someone. Ariana tried to keep Taylor awake, and Miss Ryan attempted to put a tourniquet on Natalie's arm and comforted her. Miss Irimie acted. Her last act on this earth was to push her door shut to protect her students. When the shooting started, Coach Aspinwall acted. He went outside his classroom to see if he could help. Coach Phoenix acted. After being shot, he crawled back into his room and used his last bit of strength to shut his classroom door to protect his students. Valerie Lancaster acted. She used her training from Girl Scouts and stopped the bleed to save Coach Phoenix's life. And Sweet Mason, he didn't even have the opportunity to act. On September 4th at 10:22 a.m., SRO Donovan Boyd yelled into his radio, "Active shooter."
Active shooter. What? Active shooter at Apalachee High School.
And at that moment, every law enforcement in Barrow County and every law enforcement officer near Barrow County acted. 58 agencies and 400 law enforcement officers came to Barrow County to answer the call for help. Within a minute of hearing those first shots, SROs Boyd and King took the shooter into custody and saved Zane Zinni's life. He was in that last hallway seconds from being shot by Colt Gray. Sheriff Judd Smith and Lieutenant Wilkerson acted. Sheriff Smith was one of the first responders and helped get Natalie to EMS quickly. And Lieutenant Wilkerson did everything he could to save Miss Irimie's life. And the incredibly quick response by EMS and law enforcement saved the lives of Coach Phoenix, Natalie, Taylor, and Melanie. Ladies and gentlemen, at the end of those 41 seconds, the sense of security that this school and this community once had was shattered. But also in the aftermath of those 41 seconds, a community united, heroes emerged. Parents from all backgrounds came together on the football field to try and find and embrace their children. And every person in this community wanted to know one thing: who did this and how did this happen? Everyone except for that man, the defendant, Colin Gray. He was not asking that question because he knew exactly who had done this and how this happened.
God. I knew it when my little girl just texted me. She's in middle school. She said, "We're in lockdown." I'm like, God, please tell me, brother, do something. Why do you?
In fact, that man was the one person who could have prevented this mass shooting. He was the one man who ensured that Colt Gray had the tools he needed to commit mass murder. Ladies and gentlemen, that man and his son are both responsible for the immense suffering that occurred on September 4th. The blood is on their hands, and the defendant needs to be held accountable for his actions that led to the murder of 4 people and numerous other injuries, both mental and physical. I know this case has had testimony that was difficult and upsetting to hear, but I want to thank you again for your service as jurors. I have 2 opportunities to speak to you, like Judge Primm just said. After defense counsel gives their closing argument, I'll come back before you and explain why the evidence has proven the defendant guilty beyond a reasonable doubt. So right now, I'm going to briefly go over some of the law that the judge is going to give you to help you put some of the evidence in context. One thing he's going to talk to you about is the elements of the crimes that the state has to prove beyond a reasonable doubt. The defendant is charged with 29 crimes in the indictment. All of these crimes were committed in Barrow County. Apalachee High School is in Barrow County. The defendant's house, where he gave Colt access to the rifle and ammunition, is in Barrow County. So the first charge we're going to talk about is murder in the second degree. The defendant is charged with 2 counts of murder in the second degree for Mason and Christian, because they were the 2 children that were killed. To prove this, the state must show that the defendant caused the death of another human being, irrespective of malice, by committing the offense of cruelty to children in the second degree. When a child dies during the commission of cruelty to children in the second degree, then that is murder in the second degree. This is not malice murder. That's a completely different crime. No malice is required for second degree murder. And that means that the defendant did not have to intend for Christian or Mason to die. The state, however, does have to prove that the defendant's actions were the proximate cause of these deaths. That is, that his actions played a substantial part in bringing about or actually causing the deaths, and the deaths were reasonably foreseeable. For the first prong, at the age of 14, Colt could not legally buy a rifle or ammunition. He was too young. He also was too young to even drive to buy a firearm illegally. But for the defendant providing his son with a rifle and ammunition, these deaths would not have occurred. If you find the defendant guilty of cruelty to children related to Mason and Christian, then you have necessarily found that the defendant's actions played a substantial part in causing their deaths. As far as reasonably foreseeable, the state has to prove that these deaths weren't a remote possibility, but something a reasonable person could see happening. I like analogies, so I'm going to use a few throughout this closing. It's not to be flippant, but it's to try to explain the legal wording in a context that's relevant or more easily to understand. So here's my first one. Think about road signs, like the one that warns of falling rocks from a cliff. If you drive by that sign, you may not know exactly when or what type of rock is going to hit you, but you're on notice that if you drive by a cliff, you might get hit by a rock. Warning signs make something reasonably foreseeable. And ladies and gentlemen, we'll go through all this evidence in the second closing, but there were months and months and years of warning signs leading up to September 4th. Any reasonable parent, any reasonable person would have foreseen that Colt would harm somebody. Even 13-year-old Jenny Gray saw this coming. Jenny told the defendant, "But I think we are thinking the same thing, and I don't want to talk about it over text." And the defendant's response was 10-4, because he certainly saw this coming too. He is guilty of these charges. Next, we have 20 counts of cruelty to children in the second degree. To prove this charge, the state has to prove that the defendant caused cruel or excessive physical or mental pain to a child under the age of 18 years through criminal negligence. For the first element, the defendant caused this pain by consciously disregarding a substantial and unjustifiable risk that his act of allowing Colt Gray, a minor over whom he had custodial responsibility, access to a firearm and ammunition, after receiving sufficient warning that Colt Gray would harm and endanger the bodily safety of another. And thereafter, Colt Gray did shoot at and shoot children. That's what is in the indictment, and I know it's lengthy, but that is what the state has to prove. So to break this down a little, I want to first talk about the act that the defendant committed. The defendant gave access to a semi-automatic rifle and ammunition to his son, Colt. His son, who was a minor over whom he had custodial responsibility. Now, Colt lives in the defendant's house. The defendant bought him the rifle. The defendant had the ability to take that rifle away if he wanted to. The defendant gave this access to Colt after he received sufficient warning that Colt Gray would harm and endanger the bodily safety of another. Now, the defense in opening misled you about this part of the law. They said we had to prove that the defendant unequivocally knew that Colt would harm someone. This is not what the law is. This is what they want the law to be. But what the indictment says, what the law says, is that we have to prove the defendant received sufficient warning that Colt would harm someone. Sufficient warning. Here's another analogy. If you see a weather report saying there was a 70% chance of rain, then you've received sufficient warning that it would rain, and it's your responsibility to bring an umbrella. When looking at the evidence in this case and deciding this case, keep in mind what the actual law is and what the state has to prove. Listen to the judge as he charges you on the law. Remember, it is you, the jury, who decides what is sufficient warning. And you've heard the evidence and you know that the defendant was sufficiently warned that his child would hurt someone. I also want to point out that the judge is going to instruct you that when an count on the indictment charges that the defendant committed a crime in more than one way, you may convict him if the evidence shows that the crime was committed in any of the ways on the indictment. Essentially, what that means is if there is an and in the indictment, it means or. So, for example, in cruelty to children, we charge would harm and endanger the bodily safety of another. But all the state has to prove is that it would be would harm or endanger the bodily safety of another, not both. So if we prove one, then the defendant is guilty of that charge. And that goes for any time there is an and in the indictment. It means or. When the defendant gave Colt this access to a firearm and ammunition, he consciously disregarded a substantial and unjustifiable risk that Colt would hurt someone. The term conscious disregard is defined as rising to the level of a gross deviation from the standard of care a reasonable person would exercise in this situation. And finally, the harm, as we know, occurred when Colt shot at and shot children at Apalachee High School. That's the first element of cause for cruelty to children. The second element is cruel or excessive physical or mental pain. The state has to prove that each of the victims listed in the indictment suffered cruel or excessive mental or physical pain. I know those kids' testimonies were heart-wrenching and difficult to listen to, but we had to call them to testify in order to prove this element. Each and every one of them had cruel and excessive physical or mental pain. You have Taylor, who still walks with a limp, has had countless surgeries, sleep terrors, and anxiety. Natalie does not have full use of her hand and has PTSD. Melanie took 6 months to recover, missed her soccer season, and still has images of that day stuck in her head. Nonica can no longer play sports. She had nightmares and thoughts of suicide. Jackson has been unable to go back to school because of what happened, and he had to give up something he loved, the marching band. Ronaldo became more aggressive, had bad dreams, and could not hug his own mother. Hayden has panic attacks and lives in fear that this will happen again. William sent his family a text message after the shooting telling them he loved them and that he thought he was going to die. Kendez has nightmares and spent a year and a half believing that he had left the door to his classroom open. Marquez constantly thinks about what happened that day and has even lost his love of sports. Brittany is scared easily and is triggered by loud noises. Michaela is traumatized and is scared to stay home alone. Jalen has more anxiety, and Martin is constantly looking at doors, afraid of what might happen. Ariana started anxiety medication and has intrusive thoughts of Christian. The second element is met. And of course, for the third element, you heard either the students or Ms. Ryan testify that they were all under the age of 18. The final element for cruelty to children in the second degree is criminal negligence. That is defined as an act or failure to act which demonstrates a willful, wanton, or reckless disregard for the safety of others who might reasonably be expected to be injured. The defendant is not charged, again, with purposely or intentionally bringing about the harm, but with recklessly doing it. And reckless disregard for the safety of others describes exactly the defendant's actions in this case. So those are the two charges that are related to the child victims. The next two charges we have are related to the adult victims. That is involuntary manslaughter and reckless conduct. The first charge we're going to talk about is involuntary manslaughter, which is the corresponding charge for adults for murder in the second degree. The defendant is charged with 2 counts of this against Coach Aspinwall and Ms. Irimie. In order to prove involuntary manslaughter, the state has to prove that the defendant caused the death of another person without intending to do so by committing the offense of reckless conduct. Again, the defendant did not have to intend to kill these people, but if someone dies during the commission of reckless conduct, then that is involuntary manslaughter. For all of the adult victims, there's also a charge of reckless conduct. And again, this is the corresponding charge to cruelty to children when the victim is an adult and not a child. And it is laid out the exact same way as the cruelty to children charges. In order to prove these counts, the state has to prove that the defendant caused bodily harm or endangered the personal safety of another by consciously disregarding a substantial and unjustifiable risk that the defendant's act or failure to act would cause harm or endanger the bodily safety of another. And clearly the defendant's actions in this case constitute reckless conduct. Before I move on from discussing the charges, I need to talk to you about something called lesser included charges. What that means is the defendant is going to ask you to either find him not guilty or find him guilty of only a lesser charge. He wants you to do exactly what he does every time he talks. Make his actions seem better than they actually were. On this verdict form, which you'll have with you back in the jury room, it'll have what the state indicted the defendant at the top, and then under it, it'll be the 2 lesser included charges for murder, and then there'll be 1 lesser included for involuntary manslaughter. I'm going to start with the first lesser included for murder in the second degree. For that one, the defendant wants you to find him guilty of only the lesser included charge of involuntary manslaughter, like we just talked about for the adult victims. He wants you to find that Mason and Christian died in the commission of a reckless conduct instead of a cruelty to children in the second degree. The only way you can find this lesser charge is if you find that Mason and Christian did not suffer cruel or excessive pain. Since Mason and Christian are under the age of 18, that's the only additional element that separates cruelty to children from reckless conduct. To find that Mason and Christian did not suffer cruel and excessive pain, you would have to put aside all logic and common sense. These children paid the ultimate price for the defendant's actions, and there is no argument that their pain wasn't both cruel and excessive. Ladies and gentlemen, when you go back to the jury room, read the indicted charge. Read what murder in the second degree is on the indictment. If you find him guilty of that charge, leave the other 2 blank. And remember, if you find the defendant guilty of cruelty to children in the second degree, because Mason and Christian died during that act, that man is guilty of murder in the second degree. The law is that simple. For involuntary manslaughter, the defendant is also asking that you find him guilty of the lesser included charge of involuntary manslaughter lawful act. What he is charged with currently on the indictment is involuntary manslaughter, unlawful act. This is also going to be a second lesser included of murder. So for second degree murder, it'll have involuntary manslaughter, unlawful act, and involuntary manslaughter, lawful act. And then for involuntary manslaughter, it is going to say the indicted charge is unlawful act, and the lesser included is lawful act. The judge is going to instruct you that this version of involuntary manslaughter means that someone dies in the commission of a lawful act in an unlawful manner. An example of a lawful act in an unlawful manner is building a porch without a permit. It's lawful to build a porch. It's unlawful to do it without a permit. Ladies and gentlemen, what this man did is not the equivalent of not getting a permit. This man in no way committed a lawful act. Buying a gun for the purpose of transferring it to your 13-year-old child is illegal. A reasonable gun owner would secure his weapons just because he had children. It is certainly a gross deviation from that standard for the defendant to let a child like Colt Gray have a rifle in his room. For the adult victims, find the defendant guilty of the indicted charge of involuntary manslaughter, unlawful act, and leave lawful act blank. And for the child victims, again, find him guilty of murder in the second degree and leave the other two blank. Essentially, the defendant wants you to convict him only of something that is barely a crime because it was committed doing a lawful act. Don't let these lesser included charges confuse you. The defendant is guilty of what is charged in the indictment. The defense claimed in opening statements that if you find the defendant guilty, it's a slippery slope, and parents will start getting charged all over the place for crimes their children committed. Ladies and gentlemen, the defendant is not charged with these crimes because he is Colt's parent, because he shares his last name. He is charged with these crimes because he shares the blame. Think about it this way. Our children do risky things all the time. For example, a 16-year-old driving a car is inherently risky, but parents let their children drive because it's a justifiable risk. A parent does not commit a crime if their 16-year-old gets in a car accident and kills somebody. However, if you give your 16-year-old a six-pack of beer, watch him drink it, see him fall over the place, help him up, then him driving, now that's become an unjustifiable risk. If you disregard that risk and give your child the keys to the car and watch him drive off, and then he kills someone, then yes, your actions combined with your knowledge are criminally negligent and they're reckless, and you're guilty of murder in the second degree or involuntary manslaughter, depending on the age of the victim. But that's because of the parent's own actions, not just because their child did something. After seeing sign after sign of his son's deteriorating mental state, his violence, his school shooter obsession, the defendant had sufficient warning that his son was a bomb just waiting to go off. And instead of disarming him, he gave him the detonator. Charging the defendant is not a slippery slope. It's reasonable, it's common sense, it's justice. The last part of the law I'm going to go over with you is reasonable doubt. The judge is going to tell you that the state has the burden to prove all the elements charged in the indictment beyond a reasonable doubt. Reasonable doubt is a doubt of a fair-minded, impartial juror who is honestly seeking the truth. It is a doubt based upon common sense and reason. When you seek the truth, you do not abandon your common sense. Use your common sense when you are deciding this case. Think about it like this. In Wheel of Fortune, there's a moment where contestants know exactly what the phrase is, even if all the letters are missing. The moment you know that the defendant is guilty, even if there are some missing letters, that is the moment that you have found beyond a reasonable doubt. Now, the defense attorney is going to get up here and do his job and try to convince you to acquit the defendant. Then I'll come back before you and do my job and explain why the evidence has proven him guilty beyond a reasonable doubt of all the charges. And as you listen to these final two closings, keep in mind what your job is. Your job is not to look for doubt. Your job is to honestly seek the truth. And in this case, if you look for the truth, you will find that there is no doubt that the defendant is guilty of all charges.
Thank you, Hunter. Yeah.
Sir? Yes.
Good afternoon. I want to thank you for your service. It's people like you who take time off from their work, from their daily lives, to come to court and be sure that our justice system is preserved. And for that, we want to thank you. You do this. You don't grumble about it. You come in here and you do your job. We appreciate that. A good jury is a cross-section of the community. Each one of you comes in here, you have different jobs, you have different religious backgrounds, come from different places, but you all share different experiences. And that's why it's good to have a cross-section of people, because each one of you has something to tell the other. Each one of you can look at a case a little differently than the other. The state gave you some charges that we feel the judge will read to you. I want to go over just a couple more of those, and then we'll get into what we believe the evidence showed or not showed. I think the cradle of American liberty is the burden of proof. Very simply put, the state has the burden of proving this case to you, not to a reasonable doubt, but beyond a reasonable doubt. That's what makes our system work. Presumption of innocence. Colin Gray, when he came into this courtroom, was presumed innocent. That presumption of innocence stays with a person until it's overcome by competent legal evidence. Reasonable doubt. Brooks went over a little bit about reasonable doubt, but simplified is it's a doubt for which you have a reason. It can be because of a conflict in the evidence. It can be because of a lack of evidence, or any number of things. If you are not satisfied and your minds are wavering and you're saying, well, you know, I didn't hear about this, I've got a problem with that, then that's a doubt of the law and you should acquit. The court's also going to tell you about grave suspicion. Grave suspicion, it merely puts upon a defendant a grave suspicion of a crime charged, or merely raises a speculation or a conjecture of the defendant's guilt, is not sufficient to authorize a conviction. Speculation and conjecture is something that we have heard in this case. A lot of speculation. Why didn't you do this? Why didn't you do that? A lot of conjecture. It's important to keep that in mind. I want to go over just a minute with you the indictment. I'm going to try to simplify it as much as I can. I know Ms. Brooks went over it initially. But in counts 1 and 2 of the indictment, to simplify it, you're going to have to find cruelty before you can even get to the murder in the second degree. You're going to have to do that for counts 1, 2, 3, 4, and basically 5 and 6. You're going to have to find an underlying charge before you ever get to the main charge. There's a lot of terms here, a lot of things that the court's going to tell you. You're going to hear criminal negligence, you're going to hear proximate cause. All of these are important for you to understand when you're plugging in what the state has said in their indictment. And this is what they say. That criminal negligence in the child under the age of 18, cruel and excessive pain by consciously disregarding a substantial and unjustifiable risk. And that this act of allowing Colt Gray, a minor over whom he had custodial responsibility, access to a firearm and ammunition. Let me stop here, because Georgia law does not require a gun be locked up or ammunition be locked up. So that's not a criminal act. Having a gun in the house, having ammunition in the house is not a criminal act. So don't forget that that's not the case. That's not the criminal act, supposedly, that they're indicating. And in the indictment, they indicate that Colin Gray knew that this would happen. That's real important, because that really is the key to this case. Is what did he know? Did he know that Colt would do this? What evidence do they have that points to he would do it? That's what they've alleged in their indictment. And if you'll remember, District Attorney in his opening statement told you he knew it. He said he knew that this was going to happen. How did he know it? Got a child with some issues, but how did he know it? Was there anything that showed that he knew it? That there's a gross deviation. What's gross deviation? That's something that you're going to have to figure out. Was this a gross deviation where he allowed his son to have this gun? It's not illegal to have. These are things that you'll have to look at in the indictment and have to make your decision about. What a horrible thing for these children to have to go through. Something that no child should have to endure. The loss of a child by a parent is difficult. Loss of a husband or a wife in a situation like that is horrible. And we're not saying it's not. First part of this case, they went through all of the horror that these children went through. But that's not really what this case is about. It's not that you decide this case on emotion. You have to decide this case on facts and the law. It's the only two things. You know, when you took your oath to be a juror, an oath is a promise. And you promised us in that oath that you took that you weren't going to be biased, that you were going to look at the facts and circumstances and render a fair verdict based on the law and facts. I know that's hard in a case like this. You've got a lot of pressure. Everybody in this community wants to see somebody go to jail other than this young man right here. This is the person who went into the high school and shot and killed 4 people he didn't even know and injured scores of others. This is the person who needs to be punished. He made a conscious decision to do this, a secretive decision. This is the person that should be punished. He's being charged as an adult, which means he suffers the same consequences as an adult would if he were charged in the case. We were not able to have him testify, nor was the state. The reason is that we couldn't call him because his attorney would not allow us to do that. It would be hearsay if we attempted to do that. Had he been tried first, maybe we could do that. Maybe we could get some answers to some of the questions that still linger for all of us. Who is Colt Gray? We found out that he was a smart kid, obviously. He was able at 11 years old to get behind a firewall at school and do searches. I wouldn't be able to get behind a firewall at my age and do any searches. So at 11 years old, that's pretty good. So we know he was a smart kid. We know that he kept dark secrets. How do we know that? Because he was on that computer. He was on a computer with a dark web. We know that because Jenny told us he had a number of different accounts. He was always changing his password. And this is where he got information about these individuals that you see on this board. Nicholas Cruz, among others. He was secretive in that he didn't tell everybody what he was doing. He certainly didn't tell his dad. You're not going to find one email or one witness that tells you Colt told his dad he was going to do a shooting. Look at all of the evidence that you have over here and over here. You got 60,000 pages of text messages, 60,000. Not one of those text messages informs him of anything that he's going to do to harm anybody. We know that Colt had some mental issues. We're not trying to get around that. But what was the extent of those mental issues? We don't even know today, as we are here, what those mental issues were, even today, over a year after this incident. And even if he had been taken to a counselor, as manipulative as he was, do you think he'd be able to get around that counselor, convince him that he was fine? It was his parents that were the problem. They thought he suffered from anxiety and depression. Had these volatile temper tantrums. As I said, the first days of this trial were pretty emotional. An awful lot of evidence that you have to look at. but certainly we want you to look at it all. They're going to have to show that this was an anticipated and a reasonably foreseen incident on the part of Colin Gray. Well, who would be able to foresee that a 14-year-old is going to take a rifle, I don't know where it is, as big as it is, as heavy it is, and stick it in a book bag, get on a bus, come to school, walk down the hall, go to class, put it down on the floor, and not one single person sees it? How foreseeable is that? And on top of that, then we have, what is foreseeability in some other people at the school? At 8:46, Miss Harris sends an email. Got a kid in my class who's asking about school shootings. 8:46. Then after her class, she goes to Ms. Martin's office, one of the people that she emailed, and tells her, I believe I saw a gun. Did they shut the school down right then? No. It's 9:40. 23 minutes, Colt Gray is sitting in class before he leaves. They got 23 minutes to figure out where is this kid that's made this threat and maybe has a gun. They didn't find it. They don't take anybody that knows what he looks like. They didn't ask, what does this kid look like? They don't get a description of him. They go pull another Colin Gray out of the bathroom. Doesn't look anything like Colt Gray. Apparently, nothing was ever said about there being two Colt Grays in the same class. And during the time that they are pulling Colin Gray out of the bathroom, Colt Gray is in the same bathroom. Foreseeability. People miss things. School officials miss things. It's not unusual sometimes that people miss things. An hour and a half, Colt Gray was in the school with a gun, and nobody found him. A gun that takes 7.5 pounds to pull the trigger. The ammunition was hunting ammunition. It's an AR style, not a machine gun. You don't hold the trigger down and it keeps firing. It's semi-automatic, like a 9mm or many other rifles that people purchase. Let's talk about the people that knew the most about Colt, his family. Debbie, his grandmother, told you that he was her favorite, his firstborn son. Told you that he was very manipulative. I think you saw that on the text. If he didn't get what he wanted, he would pitch a fit. Not like some other children. Don't get what they want, they pitch a fit. She told you about the comings and goings of Colt, Colin, and Marcy, and the other children. when they were there in Fitzgerald and when they weren't. She told you about an incident when Colt and his mother got into it. Mother slapped him. He broke a pane out of the glass door, slamming the door. And she called DFAX. DFAX intervened. This, they want to tell you, is a red flag, where Colt was slapped by his mother and he slammed the door too hard. It was an allegation that he was stabbing the couch. What Debbie told you, that Marcy lied, and she didn't know whether he did that or not. And of course, Colt denied to his dad that he did that. Told us about she didn't know, but we heard later while he was there in Fitzgerald, he'd cut his arm. Was that the last time he cut his arm? This is interesting. The state brought a picture up and showed it to Colin Gray. You're not going to see that picture. We don't believe that that's his arm. Take a look at the picture over there of him. There's no cuts on his arm. Let me tell you, if those cuts had been on his arm, the police officers, when they arrested him, they would have taken pictures of that. They took the other pictures of the upper arm several years ago when he cut himself. Why is that picture not in? Because they can't prove that it was his arm. Nobody else saw it. Debbie didn't see it. Marcy didn't see it. Jenny didn't see it. Coley didn't see it. Colin didn't see it. So where in the heck did that come from? Doesn't make any sense. She told us that she bought Colt a phone when he went back with his dad so that they could stay in communication. And that she talked to him a lot. That she came to Barrow County and to Jefferson County to see him almost every month. She purchased for Colt ammunition and clips. Why would she do that? Because she was glad that he had something that he enjoyed doing. Going hunting with his dad. Bonding with his dad. She was not displeased with him purchasing this gun back in December. Otherwise, she would not be purchasing all these items for him. And it's interesting, during the time that Colin and Colt were together in Jefferson and here, we didn't hear one thing about any altercations between Colin or Colt. One of the big things that they want to talk about is this May 23rd, when Jefferson County sent a sheriff's deputy out to the home. You got to view that video. When they came to the home, Colin, come on up on the porch. I'll get him out here. You talk to him. You didn't try to hide anything from him. Come out and talk to me. They talked to Colt, talked to Colin. And Colin tells them, if there's anything to this, all the guns in the house are gone. At that time, Colt gun had not been purchased. It didn't get purchased for about 7 or 8 months later. But the thing is, they want to say that that is a red flag that Colin should have known by them coming out there. But what did they say? You know what? We don't believe that your son did this. The follow-up phone call was the next day. And they told Colin, we don't believe your son did this. This came through some California website. It was in Russian. We don't know what this is. Never was there a follow-up. Never. Has there been one police officer or official that has ever told Colin Gray, your son is a threat and you need to throw the guns away? No. You didn't hear that, and you won't hear that because there wasn't any. Debbie tells us that unfortunately, she was tied up by her daughter, Marcy. Marcy was on drugs pretty heavily, and she had the two children down there with her in Fitzgerald. DFACS took those children, and they called Colin and said, will you come and get these two children? He didn't hesitate. He didn't say, no, I don't want my children. He loved his children. He wanted his children. So he went down immediately and he brought them back. And because of that, Marcy was pretty upset. She had lost the two children. So what did she do? She wanted to borrow her mother's car. She said, I'm going to kill Colin and Colt. Now, if you're a 13, 14-year-old boy and you hear that your mother wants to kill you, what do you think that does to you? You think you might not be real happy with your mother at that point in time? You think that you might think, you know, she might really do that. She might kill me. Debbie indicated that she helped Colin from time to time. She indicated that, and of course, I'm sure the state's going to talk about the 8th grade, what happened in the 8th grade. At the beginning of the 8th grade, Colt was in Fitzgerald. He was not registered. They attempted to get him in virtual school. Didn't work out. Then he went back with his dad. As he testified to you, he asked his sister to help, asked Debbie to help, try to get Colt into a program, and actually believed that Colt was. So you'll find some of these emails or texts where he's texting and saying, how's school going? You know, what are you doing class-wise today? And Colt is not telling him the truth. He's lying to him about doing the schoolwork. Debbie says that she got a call from Colt to come and get Marcy, because after Marcy got out of rehab, it was decided in the family, let's bring her back and see how that'll work out. She was there about a month. But during that month, she caused all kind of havoc. Debbie told us that she had to come up and retrieve Marcy because of an altercation between she and Colt. She also told us that she had come up here on the 28th and met with Lisa Butler. Talked to Lisa Butler about getting Colt into some therapy. You also heard on the 26th, Colt texts Debbie and says, if I do something bad, will you still love me? Of course, she texts back and said, sure. You know what? She never told Colin that. This is one of the problems. Things happen and nobody tells him. How's he supposed to get this? Through osmosis? People don't tell him things. How's he going to know? And Debbie says that while she's up here getting Marcy decides to put Colt on Zoloft. And she said that when she was here and talked to Lisa Butler, she talked to Colin about filling out paperwork to get the counseling. And he did that. The state kind of poo-pooed on that, and they said, well, it took you 24 hours to fill out that paperwork on one page. It's not that he didn't do it. You're going to condemn him for waiting a day? This is kind of the way this thing is going. They want you to connect dots from the second grade for a 7-year time period and say, well, you should have known that he was going to commit a murder because he wrote some graffiti on the wall in the second grade, or because he went behind a firewall in the third grade or sixth grade. They want you to connect those dots for a 7-year time period. What happened to the other 364 days of the year? What happened to all of the other time period? They want to pick out these different things over a 7-year time period and say, you put them all together and this is what you got. But as a parent, you don't do that. She also told us that she thought Colin was doing a great job with these children. Now, Colin is pulling the wagon. He's working a job. He has 3 children, not just Colt, but he's got 2 more. Colt's not easy, but he's having to feed and clothe, pay rent, pay all of the bills that need to be paid. He's pulling the wagon. Nobody wants to talk about the other 2 children who are going to school, not being late, and doing what they're supposed to do. They wouldn't be doing that if it wasn't for him. He's the one that got them up, got them going, got them to school. The problem child is Colt, and he was doing the best that he could to figure that out. It's interesting, too, that Debbie never told Colt, you need to put these guns up. She never told him that. Let's talk a minute about Marcy. You've got an opportunity to hear her as she described herself. She's a good mother. I think we'd have to beg to differ on that. She told us, and really tried to make light of many of these issues. It seems with Marcy, nothing is her fault. Everything is somebody else's fault. And apparently she had no problem with Colt and Colin going hunting. Apparently she had no problem with Colt going to the firing range. And apparently had no problem with the gun being in and around the house. because you're not going to find one single text message or email from her telling Colin to put the guns up. Your son is a threat. Not one. I had a big stack of emails and text messages. Not one of them. They had one conversation after Marcy was there and got into the altercation with Colt when she grabbed the gun and he took it back away from her. And that's when she said, you need to put the guns up. That's the only time. It's interesting too that neither Debbie nor Marcy nor Jenny nor Collie never saw any ammunition in Colt's room. There's one photograph that's in the group that shows some ammunition, a box of Winchester ammunition. Was that when Debbie bought it and then it got put up? Ammunition was kept away from the gun. The rule was no ammunition in the gun. It's in a different place. And a gun without ammunition is just a gun. Marcy told us, I didn't see this coming. Here's the woman who is talking to Colt about school shooters. Here's the woman who knows that Colt has put $20 on Nicholas Cruz's account. Here's the woman who's doing searches of school shooters. Here's the woman who's watching documentaries, none of which she told Colin about. There's not one single email about that. The state's going to bring up this right after she was doing the searches. It was a 11 or 14 minute telephone call where the state's going to say, it's interesting that right after she does these searches that they're talking on the phone. Neither Marcy nor Colin say that they were talking about the school shooting or looking up what happens to parents in school shooting. They were talking about the Saturday that she was going to come up. That's what they were talking about. If you remember, they were going to come up, she wanted to come up on Saturday and take Colt to Advantage. But that didn't happen. Didn't happen because Colin didn't want it to happen. He didn't want her to get up here and have another altercation, Colt have another altercation with the mother. Plus, it's a 4.5 hour drive down there. And a 4.5 hour drive back. That's 9 hours. So what did she expect? He's going to drive there, leave at 6 in the morning, and then drive another 16 hours total there, back, and still have time to take Colt to Advantage. Doesn't make any sense. That was not going to be the plan. But as much as Marcy tries to throw Colin under the bus, she said to you, I didn't tell him about it. I didn't tell him about these searches. I didn't tell him about Colt's obsession with shooters. I didn't tell him about the money that Colt got from his dad that he lied about. Matter of fact, she laughed about it. And she says, I didn't see it coming. talked about the email back in the 6th grade where Colt looked up how to kill your dad. Colt explained that to his dad. As you heard, there were a number of boys that were talking about it, and he just looked it up. We don't know whether any of the other boys got ISS like he did. We know that Colin wasn't even told about it for a couple of months. We don't know whether there were any counselors that talked with him at that point. We don't have that information. What else did Marcy do? Well, she keyed writing something nasty on Colin's truck, causing him to lose his job. Hard to get another job in the business that he's in. But he was able to get a good job, and he was making good money. And he was buying his children things. Not only Colt, but Jenny, and little Colt. Just like most parents would do. The altercation that she had with Colt when she came back here after she had been in rehab, she told a different version than what Colt told his dad. And it's interesting that Jenny also said it was mother who went and got the gun. So who would Colin believe? Jenny and Colt, or Marcy, who lies all the time? Marcy is the one that dyed Colt's hair blonde shortly before this incident. She believed that Colt had anxiety and depression. And she told you that she had talked to her psychiatrist about Zoloft. Why did she not talk to her psychiatrist about Colt? Why did she not say, he's having some anger issues, he's having anxiety, what do you think we ought to do? She never did that. It's interesting too that Marcy, when she was here, never said anything about seeing this collage of photographs. It's been shown to you a ton. She never saw it. Debbie never saw it, which is interesting because she said, if you remember, she came up here to clean up Colt's room. So surely if it was on the wall when she was here, she would remember it, but she didn't. Marcy told us that everybody was on board with getting Colt therapy. She told you that Colt had said he wanted to kill his dad another time. But she also told you, I never told Colin about that. So how's he going to know if somebody doesn't tell him? she says, I didn't see it coming. And then she said, I can't picture him hurting anyone. It's the last thing that I would have thought. That's what she said. You heard from Jenny. Big difference when she came in to testify to you as opposed to the statement that we played. She told you when she came here in her testimony that Colt always kept his door closed. She also said that her dad asked to cover for him. Cover for what? Ask her to lie about what? He gave 2 long statements to police. He told them a consistent story about picture, consistently that there was one picture. He came back and said he was told that it was Nicholas Cruz. But what else? What else did she lie about? State didn't ask her. So let's go through what she said in her first statement. She said her father was a happy and energetic person. And we know that because of the text messages that he sends to the children, and you'll be able to look at those or talk about them back. He's always telling them that he loves them. He's encouraging them, especially Colt. He's encouraging him to go to school, do the right thing. You're a good young man. I love you. Encouragement from parents that you would expect. Not getting that same kind of encouragement from Marcy. She said about her mother that she was overbearing and annoying. When Colt got in a mood, he would instigate stuff. She told you about when he would get mad and he would rush at Colin, and Colin would bear hug him and hold him until he calmed down. And then she said something interesting. Colt would always apologize. He would always come back and say, I'm sorry. She said that her dad was close to getting him in therapy. And she told you about the burner accounts that Colt had, that he had numbers of accounts, and his dad did not know. She said specifically, Dad doesn't know anything about it. She said that Colt had talked with her about school shootings. But Dad didn't know. She never told Dad. She said Colt had been bullied. I think she felt like that probably was a reason that he had these anger issues. And then she said, the morning that this happened, I saw this book bag, and it didn't look right. I knew there weren't assignments that early. And when he left, I went in and looked for the gun. The gun wasn't there. But she didn't call her dad. She didn't call Colin and say, guess what? The gun's gone, and it looks like maybe Colt has it in a book bag. Didn't call him to tell him that. But she did call him after the incident, as well as Marcy. Marcy had been watching it, had been talking to the school. Marcy knew a lot, and she calls before the officers ever get there. And, you know, they played this segment here where Colin said, I knew it. That doesn't mean that he knew that's what he was going to do. He knew it because Marcy had already called and Jenny had called. They're trying to push it to make something that really it didn't fit. Just like this text, the blood's on your hands text. It's interesting that that text comes when Marcy and he are in a problem and he wants her out of there. And he's telling his dad, she needs to get out of here. It's going to be blood on your hands because she's already said that she's going to kill me. So that's a problem. But shortly after that text, after he texts that, he texts his dad, I like school. People here are mature. I'm enjoying school. What does that portray? I want to talk just a minute about Lisa Butler, too. On August the 13th, Lisa Butler met with Colt and Colin, and they were trying to figure out exactly what they needed to do with Colt, because most of the 8th grade he missed. So she's trying to figure out, okay, do I put him in 8th grade classes? Do I put him in 9th grade classes? Colin wants him to be in the 8th grade with Jenny. So they decide this is when your start date's going to be. So when they made that chart saying, oh, he didn't go to school here, he didn't go to school here, didn't go to school here, it was not the starting date. You wasn't supposed to go to school during those times because the starting date was started later. And that's what Lisa Butler told us. She saw him again on the 26th when he came to her office with anxiety. She talked to Colin on the phone. She tried to call him, but it was the wrong number. Colt got him on the phone. His dad got him calmed down. But Colt told her about his mother, what his mother had done to the grandmother, and several other things about the mother being on meth. And so Lisa Butler had some idea at that point about what was going on with Colt. But she put him in, I think, a calm room or a safe room or whatever they call those things. They have them in school. An awful lot of kids with anxiety these days. They even had to make a room for kids with anxiety. And she said that on the day of this shooting, she had a whole bunch of folks waiting for her because of problems that they were having in the school. She said that she got a telephone call that morning from Marcy, explaining that she thought, because of a text message that she got, that Colt was going to be doing something at the school. They talked for about 8.5 minutes, close to 9 minutes, shortly before this started. She also told us that she had Colin fill out paperwork for Jade Baker to start therapy. You saw the letter that Jade Baker sent saying, I will meet with Colt the first part of next week. I think Colin believed that it was going to be on the 5th. would have been a day later. Let's talk about Colin. When the police came to interview him, he cooperated. He gave them a statement immediately. He told them they could go in the house and search. He gave them permission to search the phones. He did everything that he could to cooperate, still not knowing exactly what and how this could have happened. He didn't have to do that, but he did. And then he gave in another statement the very next day. Didn't try to get a lawyer to go with him. Went by himself. Gave background history, told them whatever they wanted to know. Talk about the defects calling and him going to Fitzgerald to get the children. Now, does this sound like a parent that doesn't care? Does this sound like a parent who's just going to slough off his kid? He wasn't out running the road at night. He wasn't drinking. He wasn't hitting on his kids. He would come home and he would deal with the kids every night. And on the weekends, he would take them places. He did things with the kids. He wanted the kids to be happy. He wanted Colt to be happy. And he thought, and you probably will remember this, when he took Colt hunting and Colt shot his first deer, he told him going in, don't expect to even see a deer. But there he was. And he shot the deer and he told you, that was one of the happiest days of my life because Colt has accomplished something. He is going to have a bonding with me now over hunting, going to the target range. There's absolutely nothing wrong with going to the target range. There's absolutely nothing wrong with hunting. You don't have to put a gun in his name. As you remember, what Colin said was, I bought the gun at Christmas, but I told him, when you get to be of age, I'm going to give it to you. This is just for you to use. It's not yours until you come of age. Yet rules about the gun. It's not loaded in the house. That if any of these rules are broken, the guns are out of here. Now, state says, well, you know, you got these gun locks. You know, if a kid is motivated, if he's been victimized by this dark web, and we don't know exactly when all this dark web stuff started. But if he's smart as Colt was, you know what do you do with a gun lock? Take a big old pair of wire cutters, cut that thing off. Think that's really going to stop him if that's what he's intending to do? You think even locking up ammunition, he's smart enough to know, okay, when we go to the gun range or when my grandmother buys me bullets, I'm going to stick a few in my pocket. I'm going to hoard up these things. If he really made the decision that this is what he's going to do, he's smart enough to have been able to do that. You think that would have really stopped him? Colin told you he never had a reason to believe that Colt would harm anybody with this gun. He had never told him anything about harming anybody with a gun. He had never threatened with a gun. It was a trust thing. It was a trust between he and Colin because they needed that. They needed that trust because he wanted the best way he knew how to try to help his son fit in, do something that he enjoyed, feel good about something. We talked about the 3 times where Colt rushed him and what he would do. Bear hugging until he calmed down. He told you about the screwdriver incident. The screwdriver incident was where he had bought some tools for Colt to work on his computer. Apparently the screwdriver didn't fit. He was frustrated. He threw it down the hall. Colin said he wasn't even looking. He didn't even see it. And again, Colt apologized. The state's going to pick out, I'm sure, some messages that don't look great, but you got to look behind what these messages are. Look at the whole colloquy that they are having. And you'll see other messages. Did you make it to school today? I'm proud of you. I love you. You're a good young man. And all the while dealing with 2 other children. He's trying to pull that wagon the best he can. I want to talk just a minute about the investigation. See how I'm doing time right? How much time I got left here?
So 2:47 is your cutoff.
I'm working on it. The investigation in this case, the one thing that jumps out is you'll see the picture of the computer that's on the floor, and there's a drill there. Now, did anyone tell you what happened to this computer? Were they able to get the chip out of it? Were they able to look into this computer and find out when he was talking on the dark web, who he was talking to, what information they had, how long had he been talking on the dark web? We don't have any of that information. We don't even know whether there was any damage to that computer. We got 60,000 pages of other stuff, but we don't know what all was on Colt's computer. Another thing we don't know, we saw on the video at 8:03, he's texting somebody. It certainly wasn't Colin, it wasn't Marcy, it wasn't Debbie, it wasn't Jenny. So who was it? Was it somebody on the dark web? Was it somebody telling him, hey, watch the news, I'm getting ready to do something? We don't know. Important to know how long Colt had been planning to do something. Another thing that was interesting, you see back there, I think it's number 46 maybe, there's a trash can. And in that trash can are the boxes for this ammunition. Where was this trash can? Was a trash can in Colin's room? Was a trash can in the kitchen? Was a trash can in Colt's room? Wouldn't it make sense that he would be loading that gun that morning and throwing it in the trash because that's what's on top of the trash. You can see it. But we don't know where he loaded the gun. We saw one shell apparently that fell out when he was loading that landed in a mask. You know what room that was in? And this photograph of the cutting in April. What in the world is that about? Something to try to make you think he's cutting in April, but they don't put it into evidence, and we don't even know whether it's his arm. You can look at that photograph. There's no scars on that arm. It kind of reminds me of what they used to call leptomania, and that's where a magician says, watch this hand so you won't see what he's doing with this one. They want to bring up everything in the world that they can, all of this stuff over a 7-year time period, and you're supposed to lump it all together and say, oh my God, he should have known that he was a homicidal maniac. Where's the evidence of that? It's not here. This alleged shrine that they talk about. It's interesting, they didn't even ask Jenny in the statement that they took from her first if she remembers seeing it. Charlie, who came with Debbie, Charlie is Debbie's husband, and Debbie came to pick Marcy up a few days or a week or so before this happened. They didn't see it. Little Coley apparently didn't see it. If anybody saw it, I'm sure they would have brought him in. Debbie didn't see it. Marcy didn't see it. Charlie didn't see it. So why is it so unbelievable that Colin didn't see it? You're going to have some pictures back there. Some of them are from the past. Look at them closely to see whether they match up with what was on the wall when they went over after the shooting at the high school. The gun, everybody's concerned about what this gun looks like. It's an ominous looking weapon. Same kind of weapon that they show on TV all the time. All the police have it. All the soldiers have it. Everybody has these kind of guns. You go to a gun shop, you're going to see a lot of guns like this. It's kind of the Cadillac, the flashy kind of gun. But the reality is it doesn't work any different than a 9mm. So don't let them talk to you about how bad this gun is. It's like any other gun that is a semi-automatic. As I mentioned before, there's only one picture of bullets. Nobody, not Marcy, not Debbie, not Jenny, nobody has said they ever saw ammunition in Colt's room. You know, sometimes it's just as important things you don't hear as things that you do. You didn't have one single message from Colt to anybody that he ever contemplated himself doing a school shooting. Nobody testified that they heard him say that. There's no text messages indicating to Colin that anybody believed that. There's no emails or text messages or telephone calls from any officials telling Colin, you need to be cautious. Your son is a credible threat to people. Nobody ever said that. There's one text I'm sure they'll talk about where he calls us or texts his dad about voices. Another ploy to get out of school, maybe. It was early in the morning, didn't want to go to school. This is another thing. When they talk about what's foreseeable, what can you foresee? What can you tell? The state's got to show you that he knew that Colt would, not could or not possible, but that he would. That's in their indictment. They have to prove what's in that indictment. Look at the indictment. Look at the things that they have put in there to try to focus. But the word would is pretty important. Have they proven that he would, that he knew that he would? Absolutely not. What's foreseeable and what's unforeseeable? What's unimaginable? Unimaginable that your child will commit murder. Nobody can foresee that. Nobody wants to ever think that. If you or someone you know had a child, grandchild, niece, or nephew who struggled with self-esteem, self-worth, don't make friends easily, trouble keeping up with school, been bullied, who shows signs of anxiety or depression, then you know what it's like to worry about those kids. You worry about whether they'll have friends. You worry about, will they be able to complete school? Will they find something that they're interested in and enjoy? Will they ever be happy? But all the while you think about that as a parent, you love your children and you remain hopeful. And that's what Colin Gray did. He remained hopeful. He took the children on. He didn't send them to DFACS. I'll take care of my children. I'll pull that wagon. And as he told you, I may not have done it correctly. I may have made some mistakes. But he didn't know what was coming because he didn't have sufficient warning. That's what they got to prove. And what is that sufficient warning? You think if somebody, it's not against the law to have a gun in the house or ammunition. You think everybody that has a gun in their house and their child has anxiety, then that's sufficient warning? Is it really? Is that what we've come to? The state said, you know, we don't want to charge all parents with what their children do. Just this one. What the state said, their little colloquy about someone taking the car, you know, and getting in a wreck, they're not going to charge it. Well, let me tell you, if you have a child that may have a tendency to drink, and you buy that child a flashy car, and you don't lock up your liquor, and he goes out and kills somebody, that's exactly what we're talking about. Do you want this to be the way the law is? This is the first case in Georgia like this. Do you want to make a law? You want to make the law that way? You know, with kids, there's always ups and downs. You always hope to manage their downs. And Colt had some downs, but Colin managed them. He took him to play golf, he took him to do other things, fish, and he took him to hunt, and he took him to target practice. And he never in a million years thought that this son that he loved was going to turn out to be the monster that killed these people. As he told you on the stand when the state was questioning, I never saw that evil before. You saw his reaction when he had to watch that movie. That's the typical reaction of a father who cares and did what he could. It wasn't that he wasn't going to get him therapy. It wasn't that state's going to say, well, you know, he could have done it the day before. He could have done it a week before. They had a plan. And his plan was Lisa Butler, through Jade Baker, is going to talk to Colt, and they're going to suggest to me what we need to do. I've looked at some other places as fallback places. I've emailed people. We're going to let them tell us, what does he need to do? And then I'm going to follow through with it. That was the plan. And that was going to happen. But this happened before. Ups and downs, but you got to stay positive. You got to try to keep that trust between you and your child. What never enters your mind as a parent who loves their child and who thinks they understand their child, that they could plan and carry out such a horrific shooting. The state spent a lot of time attacking the decisions of Colin, and at times even mocking his efforts with Colt. Colin was always hopeful and trying to redirect Colt to do things that would help him. Deal with his depression. State disregards those attempts and tries to demonize Colin, but it's fundamental, natural, innate in parents that they are wired to see the best in their children. We always want to see the best in our children. We always want to try to do the best that we can for our children. He bought Colt a lot of things, thinking that that would make him happy, and it would for a period of time. But you know, there's a lot of days in the last 7 years where nothing but ordinary took place. 7 years is a long time. A lot of days went by where Colt was fine. Don't follow the DAs down this slippery slope of attempting to hold parents criminally responsible for what their children do. Our Constitution is based on we the people. We the people that sit here and we the people that sit over there. And we the people demand that the state prove the case beyond a reasonable doubt. Of the three forms of government, the executive, judicial, and legislating, the judicial is the only one where we the people get to directly make a decision about our fellow human beings. You get to decide. The state doesn't get to decide. We don't get to decide. The state gives you facts. We give you facts, the judge gives you the law, and you make the decision. The state would like for you to think that the system works when you find somebody guilty. But let me tell you, the system works also when you can say to the state, wait a minute, you know, there's some things missing here. I don't understand how this could be. There's conflicts in the evidence. It doesn't fit the law. What's unjustifiable? What's a gross deviation? Gross deviation from normal. The decision is now to you. Like I told you in the beginning, we appreciate the opportunity to have you as jurors on this case. Everybody's been very attentive. And I think that's certainly important. And I know that you will give Colin every consideration based on what you've heard. And that's all we can ask of any jury. Thank you, ladies and gentlemen. And I'm glad I didn't start coughing. So, thank you.
All right, ladies and gentlemen, we're gonna take that short break I mentioned, and we'll come back and give the state's final close.